Good morning and a warm welcome with the blessings of the Honorable Founder President, Sir Dr. Ashok K. Chauhan of Amity Education Group, Honorable Chancellor, Amity University, Dr. Atul K. Chauhan, Honorable Senior Vice President U. Ramachandran, Honorable Vice President Vipin Sharma, Honorable Vice Chancellor Professor Dr. Sanjay Kumar, and Honorable Pro Vice Chancellor Madam Professor Dr. Ankita Chakrabarti Bhattacharya. We at Amity University Kolkata has organized this one-day workshop on IPR under National Research Development Corporation, NRDC, Ministry of Science and Technology, Government of India, and Amity Innovation Facilitation Center, IFC. I take this opportunity to introduce the workshop. This workshop on IPR under NRDC Amity IFC is the initiative under the NRDC IFC scheme. It is expected that during the operation of the scheme, new ideas will be generated in consultation with all stakeholders, which shall be shared with NRDC. NRDC Amity IFC shall act as a nodal agency and play the role of prime mover to make the IFC scheme of NRDC a great success. The objective of this workshop is to familiarize the faculty, staff, and the students at Amity University Kolkata to the IPR regime. There shall be various other activities as outcome of this workshop, which will be undertaken at the university, like training of faculty, staff, and students on intellectual property rights. The workshop is expected to help understanding key aspects of the intellectual property rights, learning how to protect one's ideas and innovations, having the insights on managing patents and other IP wealth, understanding patent procedure and filing to grant in India. On behalf of Amity University Kolkata, once again, I extend a heartiest welcome to all the dignitaries who have joined online, faculty, staff, and our dear students. It is my privilege to introduce Honorable Vice Chancellor, Amity University Kolkata, Professor Dr. Sanjay Kumar. Professor Dr. Sanjay Kumar is an engineering graduate. He is MTech and PhD both from IIT Delhi in engineering. He has distinction of having done his second PhD in management. He has authored 7 books and published many research papers in national and international journals. He has worked as principal advisor in DARE Avionics Research Center, DRDO Bangalore, SSC ISRO Ahmedabad. He has been Vice Chancellor of 3 universities. He is recipient of many accolades and awards for his outstanding contribution in academics. He has been conferred Bharat Vidya Ceremony Award, Lifetime Achievement Award, last but not the least, for his outstanding contribution in research and selfless service to the nation. He has been conferred Bihar Gaurav Samman by Governor of Bihar, the present president, and the most prestigious President Award Vishesh Seva Medal by former President Sri Pranab Mukherjee. Presently, he is holding the honorable post of Vice Chancellor at Amity University, Kolkata. Now, I would request Honorable Vice Chancellor, Amity University, Kolkata, Professor Dr. Sanjay Kumar to deliver the welcome address. Sir.
Thank you, Dr. Manonita. Can you hear me?
Yes, sir.
Yes, sir.
Thank you so much. On this auspicious occasion of inaugural ceremony of the IPR workshop, I, on behalf of the entire fraternity of Amity University, Kolkata, extend a very hearty and warm welcome, first of all, to our Honorable Founder President, sir, seeking his kind blessing and the blessings of our Honorable Chancellor, Dr. Atul Chauhan, sir, blessings of Senior Vice President, Mr. U. Ramachandran ji, and also on behalf of the entire fraternity, staff, teaching as well as non-teaching participants, I extend a very hearty and warm welcome to the chief guest of this ceremony, Sri Raghavendra GR, Joint Secretary, Department of Justice, Ministry of Law and Justice, Government of India. Also, I'll be extending a very warm welcome to Dr. Najot Singh Khurana, Senior Manager, Law, GAIL India Limited. Also, Dr. Devashish Bandyopadhyay, Senior Principal Scientist. And last but the least, there are many speakers in the technical sessions. I definitely, on behalf of the entire university, extend a very hearty and warm welcome to all of them. My dear brilliant students, it's an opportunity for all of us to see to this that we protect something called intellectual. So far, you must be knowing this, that we have been protecting our physical property. Actually, one stalwart I just missed out, but because of him only we are here. He is Dr. S. Niyogiji. And Dr. S. Niyogiji's inspiration has been so much for all of us that we are looking at this, that it was because of him only we could get the inspiration to organize a national level workshop on the IPR. All through he has been talking to me, and we have now considered him. He is so much involved in the university course curriculums also. I have been seeking his advice, etc. And another stalwart who is known for his credentials, who is known as the biggest and the most brilliant scientist, Dr. W. Selvamurthy, whose credentials are so much. Honorable Chancellor of Chhattisgarh, Amity University. It is the greatest pleasure for us, both of you, sir, Dr. Niyogi, sir, as well as Dr. Selvamurthy, sir, to extend a very hearty and warm welcome to you. We are probably the luckiest to have you on board today to see to this that our students, our participants, they get immensely benefited by your kind presence and speeches. We are looking forward that the blessings of the Honorable President, sir, and of course, our Honorable Chancellor, who is not in India and traveling, will be also looking at this, their blessings at all time, and they are the only source of inspiration for all of them. Ladies and gentlemen, I would like to touch upon this particular subject matter and given some kind of a little orientation towards this. I was talking about this, that so far we have been very, very particular about protecting our physical property. But now when it comes to the intellectual property, many of us, we are not very much aware and ignorant about this. Intellectual property is not something new. It is something in a very, very novel things which today it has come out. And Amity University as a whole, Amity University, Noida, first of all, I would like to, give this information, the most joyful information to all of you, that the last year itself, in just, in the month of somewhere October or November, it was Honorable Founder President was conferred the best academic institution for the patents and the commercial product. And this award was conferred by Honorable Minister of the Industry and Commerce, Mr. Piyush Goyal ji. So that is how you can see to this, that how Amity University, Amity group of institutions, we are growing, and we have got the vision, and that vision of the Honorable Founder President, sir, the build the nation through education and beyond, and how we are going to build the nation. Building the nation is all dependent upon how we are nurturing our youth. You students are lucky that to have an admission in such kind of an institution of the greatest repute. I, on behalf of the Amity University, I'm also welcoming all the freshers here to see to this, that what kind of an exposure you are getting it here. National, international, all kind of an outreach activities, all kind of a research orientation, right from the day one, the day you come here, that is a time when we address myself and Dr. Ankita ji, my very, very proactive pro Vice Chancellor. We laid this emphasis on to this, that your intellect, we are bound to shape you. We are going to really sow the seeds of the all kind of innovations. And today we are saying that once you come out with innovative ideas, ingenious solution, how we are going to protect it. And that is where the intellectual property right comes. The simple, that to enhance the performance level of the institution, this is very much required. The history, if you go at this, the history is very, very long. The act was passed in somewhere in 1970. And thereafter it was amended in 2002. And that is how we are looking at this. Thereafter, the Patents Act, after the Patent Acts, the Design Act was passed. Thereafter, the trademark was passed. The copyright was asked. That is the time we have got to look at this, how the layout design of the integrated circuits, we can look at this. Any kind of a protection of undisclosed information is covered under the Intellectual Property Act. One more important aspect which I would like to highlight to you all of this, geographical indications is very, very important aspect of the intellectual property right. I'll give a brilliant example of this. The whole world is aware about this Darjeeling tea. And let me tell you that this is one of the brilliant example for this. Kanchipuram sari or anything, Maner ka laddu. I mean, all these things you can look at this. It is all connected to the geography. The next aspect is the protection of the plant varieties and Farmers' Rights Act 2001. So these are also very, very important part of this. The National Biological Diversity Act was passed in 2003. It has got lot of importance here. Now coming to the trade secrets, very, very important aspects of this. Many times you must have heard this phrase that I don't want to reveal this trade secret today. I'll give another example here, the Coca-Cola. If you look at the concentrate, today also across the world, nobody knows that what is exact concentrates of the Coca-Cola. So what are the ingredients? So that is an brilliant example of the trade secret. I mean, so is the case with many other things. In the area of biotechnology, materials kept as a trade secret that includes your cell lines, all kind of microorganisms, strains development, etc., etc. Trade secrets offer, there are a lot many advantages of this. It has got an unlimited duration. I would like to highlight this part. The trade secret has got a very unlimited duration. So it can be for the lifelong, but there are certain drawbacks to this. It's a very, very costly affair, because if it is going to be for lifelong, you have got to really pay a very high fee for this.
There's I'm sorry, there's a technical issue with the streaming of Honorable Vice Chancellor's speech. We just wait for a minute so that we get the connection. I'd request everybody to wait for a minute.
What happened actually? Dr. Monanita, we can move on to the next item. And when he joins, he can make remarks subsequently.
Hello, can you hear me?
He is back.
Yes, sir, yes, sir. Yes, sir, please.
We can hear you. Hello? Sir, we can hear you, sir.
Inventor to exclude others from any kind of manufacturing, using or selling or inventions in questions for commercial use during the specific period. Patents are granted for the inventions. I think that's hello.
Yeah, please go ahead, Dr. Sanjay.
Thank you, sir. Thank you, sir. The patent requirements are the chief requirement for the grant of the patents are basically novelty. Every idea has got to be novel and thereafter inventiveness. So the patent requirements are the novelty, inventiveness, and industrial applications and usefulness. Very, very important aspect of this. No matter how brilliant your idea is, but unless it has got certain kind of an industrial applications, it will be very, very difficult to get the patents. Patents is a very, very important thing. And Dr. Selvamurthy, who is a pioneer in these areas, and he will be only telling you that how many hundreds of the patents we have today in Amity group of the institutions across the country and abroad. It is something great to listen to him after this thing. Okay. Thereafter, the patentability. Patentability is one aspect which is the government of India and all such committee, they ascertain to this. The property which cannot be patented is a very, very important aspect. Newton's law was never patented. The scientific principles, it is very important, and I would like to underline here, the scientific principle can never be patented. A discovery of the new property or new use for known substances. It can never be patented. So these are all great aspects of the intellectual property right. One has got to understand to this what it is. Okay, then next part, which is I would like to highlight here, there are certain limitations of the patents also. Patents are only granted for about 2 decades, 15 to 20 years. All the young participants, you must make a note of this, that the patents are not for the long life, for the whole life it is not. So, you have got to really renew your patents after a couple of years as per the patents. The limitations of the space is also one of the limitations, for the patent. The copyright is another area where one has got to look at this. And here, the copyright has got certain kind of, this thing. The copyright could be in the area of the literary, dramatic work, musical work, or artistic work, or cinematography, film, etc. A sound recording, photography, computer generated work. Thereafter, then we have got lot many rules and regulations and patent acts on the plant variety protections. We have got to see to this, the plant variety protections, or how these rules are going to be applicable to this. The first law that came into picture was the 1930, the Plant Patents Act 1930 is very, very important. I would like to highlight here that this act was amended in 1970, and further it was amended in 1985. The geographical indication, what I was saying, is a very, very important aspect of this. Duration of the GI is basically for the period of the 10 years. That also one has got to understand very nicely about this, that how one can have the duration of the GIs, to be known to you. Well, ladies and gentlemen, I have just given a very quick glimpse of the intellectual property right. Once again, I am seeking the blessings of the Honorable Founder President, sir, Honorable Chancellor, sir, and our most beloved Senior Vice President, Mr. U. Ramachandran ji. Once again, I am extending a very hearty and warm welcome to Dr. Selvamurthy ji, Dr. Niyogi ji, the chief guest of the day, as at the same time, all the speakers. The university is very, very thankful and grateful to you all, sir, for your kind and gracious presence in this wonderful national workshop on intellectual property right. My blessings are going to be there always with the students, and we always strive to see to this, to meet the expectations of our all brilliant students. Let me assure at this forum, during this particular workshop, that any kind of inventions, any kind of a discovery, any kind of things you want in terms of the trademark, in terms of the logo, in terms of the trade secrets, or any kind of patentings, the university will be doing the hand holding for all the students. And today I will be glad to announce this, that Amity University, Kolkata is figuring out in the website of the Ministry of the MSME, and we have been approved that we are the host institutions. So any kind of great ideas, whatever it is there, we are going to incubate this, because we are the government approved incubation center today. And we shall be looking at this, that as many as possible, the ideas they come to us. Yeah, 24th was the last date for pushing our ideas to MSME, and from our university we pushed to about 12 ideas. And once these ideas are they get through, each project will get 15 lakhs rupees each. The mentors will also get benefited, and then thereafter the institution will get about 1 year infrastructural grant for developing the incubation center. Now we are all set to develop the best possible incubation center, where we can incubate the ideas of not only the students of this university, but also our past students, alumni, also any student from anywhere, even other states also, where the incubation centers are not there. So you can understand the seriousness of our innovations. You can understand the orientation of the entire university to develop the youth in the best possible manner, so that we can meet the vision and the missions of our Honorable Founder President, sir, as well as the Honorable Chancellor, sir. We all once again commit to the all our students, and city is all student driven. You have got to take part in every little activities, and you have got all freedom to see to this, that the university grows, you grow, you bring the laurels for yourself, for the university, and for the Honorable President, sir. Thank you so much for joining us once again. With my folded hands, I am extending a warm welcome to Honorable Founder President, sir, Chancellor, sir, for your kind blessings, Ramachandran, sir, and Dr. Silva Murthy sir, Niyogi sir,
Yeah.
everybody and all the
Dr.
speakers.
Sanjay,
Thank you very much. Jai Hind.
Dr. Sanjay, Sri Raghavinder ji has joined. Raghavinder ji, welcome.
Okay.
Thanks for joining, Sri Raghavinder ji. He is the Joint
Raghavinder
Secretary,
ji,
the Chief Guest.
Namaskar. Special thanks and gratitude from Amity University, Kolkata. We are extending a very, very warm welcome to you. Can you hear me, sir?
Yeah. Thank you. Thanks a lot.
It's a
Welcome,
greatest
welcome, Sri
opportunity to hear you.
Raghavinder ji.
Looking
Yeah.
forward.
Salva Murthy ji, namaste.
Thank you,
so
sir.
much.
Thank you, sir. Your speech was inspiring and will guide us and will serve as inspiration to the workshop as we discuss, debate, and deliberate on the ideas encompassing intellectual property rights. Now, I would like to request Dr. Shandulu Nyangi, Advisor, Amity Education Group, Director General, Amity Humanity Foundation, and Director, NRDC Amity IFC, Professor, Amity University, Noida, to address this August gathering. Sir, Shandulu Nyangi, sir, has a postgraduate degree in law, political science, and English from Calcutta University. Sir is an MBA from XLRI Jamshedpur, HR and Industrial Relations from Oxford University, Public Policy Management and International Law from Harvard University, PhD in Management from Agra University. Sir was the Director, Managing Director, and Chairman of many companies. Currently, Sir is Advisor to Amity Education Group, Director General of Humanity Foundation, and Director of NRDC Amity IFC. Sir is also the Professor of Amity University, Noida. Sir is the Advocate Supreme Court of India and also Calcutta High Court. Shandulu sir, we request you to give the address.
Yogi Sab, can you adjust your screen in such a, no, just little more. We can't see you fully, your face.
Yeah.
Unmute the mic. Please unmute the mic. Yogi Sab, please unmute.
Sir, Nyogi sir, you unmute your mic. You are on mute, sir.
Maybe I'll give him a phone call.
Yeah.
You unmute your mic, Yogi Sab. Can IT can help?
Sir, I'm sending him the request, but he's not accepting to unmute.
Dr. John, maybe you can give him a call.
I'm giving it.
Nyogi
Yes.
sir, you are on mute, sir. Kindly unmute.
You just, Yogi Sab, go to the mic symbol and then click on that.
हेलो सर, आप अपना म्यूट करिए. डॉक्टर नियोगी साहब, it's not coming. Your actually video is also not. Anyone is in and around, anybody from IT? Okay, thank you so much.
Okay.
Yogi sir, can you just adjust your camera a bit?
It is coming down. The computer is like that. I cannot help. Founder President sir is there today, and we have requested him to be present. So he has kept our request, and we are so happy. And no seminar, workshop in Amity can go without the things of the founder president. Sir, we are thankful to you for your presence. I don't know whether Atul ji is also listening to it. I requested Dr. Shrobi to send a link to him. Probably he is not here. He is outstation. So we are also thankful to Dr. Atul Chauhan because he always remains present and gives his blessing. We are also thankful to our chief guest, Mr. Raghavendra ji, and we are very, very thankful to you for your presence. So this seminar, IPR, is dedicated to the faculty members it is addressing to the faculty members and the students. And yesterday, VC Kolkata told me that the seminar will be attended by 500 students and all the faculty members. I'm so happy that the message is disseminating to maximum number of students of Amity University, Kolkata. Now, I'll tell little about the intellectual property right. Property actually means the ownership. You own something, and from there your legal provision comes in. Intellectual property right actually forms the development, basis of development. You invent something, that means you are developing not only yourself but also your community, your country. You are writing something and it is a book publication. So you are the owner of that book, owner of that journal, owner of that article, and at the same time you are protected by legal action of copyright. So the term property signifies that it can get protection under the law. It is not dissimilar to the property rights that we know. If, for example, someone steals your car, you can make a police complaint. It then becomes the job of the police to recover your property and apprehend the culprit. The same is the case of the intellectual property. If someone makes a copy of your movie or your book, you have written a book, somebody makes a copy, you can sue that entity and get relief or restitution under the law. I'll tell you because there are technical sessions and a lot of experts are going to speak to you about the IPR. I'll tell you some of them, important acts, IPR, which gives you the protection under law. Patents, the number one comes the patent, is the most important aspects of IPR. It is defined a government authority or license, conferring a right or title for a set of period, especially the sole right to exclude others from making, using, or selling an invention. When individual or organization invent or come up with a new way of doing something, they approach the patents office, gives them details about the product, or approach the patent office and get protection for the property for a fee. This is justified because this individual invests years of extensive researches, spend resources developing something, and the world would like to be compensated for these efforts. Patents act as an incentive for inventing new products and processes and form an integral part of a culture of innovation and growth. Patent protection is given only for a limited period, say for 10 years or 20 years. The next is trademark. It is also a very, very important intellectual property right. The trademark holds an important position as a unique identifier of a company or a product. It is representative of a brand, company standing to the consumers, an assurance of certain standard and quality. intellectual property protection is vital for the trademarks because companies invest a lot of time and money to develop brands. The last thing they want is some imposter selling products or services using their trademarks, deceiving consumers and leading to a loss of money and reputation of the company, deceiving consumers and leading of loss of money and reputation. Trademarks can include names, logos, and designs used in packaging of the products themselves. The third important is copyright. You may come across the phrase "all rights reserved" while watching a movie, buying a book or a DVD, indicating that the copyright is held by the publisher and no one can copy or use the material in any form without their consent. Copyright is granted to an original work, whether it is a movie, book, music, computer software, or painting. There are two types of copyright. One is moral, another is economic. Moral rights give authors to the power to be identified as authors of a particular work and to object if it is presented in a distorted or mutilated manner. The economic right is more tangible and give the author to control the use of his or her creation and reap economic rewards from it. Then comes the industrial design. Industrial design is a production technique of a certain product or article. For example, a furniture company could come up with a new way of making a sofa cum bed and may want to protect it from being copied by someone else. In many countries, the industrial design must be registered to get protection under the industrial designs law. In other countries, patents may as well do the trick. Then comes the geographical indication. Certain products are tied to a certain geographical location, and producers may want intellectual property right protection to ensure that products from other areas do not misuse this indicator. For instance, basmati rice you are eating almost every day has been registered under the Department of Commerce in India as a product with a geographical location. The tag is given only to the variety of rice grown in 7 states in the foothills of the Himalayas. Now I will tell a little bit about the NRDC, MIT, IFC. What are they doing? One of the important activity of NRDC, MIT, IFC is capacity building, awareness amongst the students, faculty members, and training. Organize regular workshops and specialized training on IPR, which we are doing now. Organize training classes for students involving internal and external faculty and experts. Conduct conferences, seminar, workshops, and intellectual property rights and technology transfer at national and international level. Next activity is IPR counseling and advices. Providing advisory support services, IPR related matters. Supposing you write a book and you want protection, once is protection, you can contact us. NRDC Amity through your Amity University, you can contact us and we will give all sorts of help in protecting by filing the copyright. Take up such activities as may deemed appropriate within the broad objectives of NRDC IFC scheme. IPR management facilitation. Facilitate filing of national and international patents through NRDC so as to generate tangible IP wealth. Then third is IPR information services. Share IPR information services to the prospective inventors and innovators by organizing IPR symposium. And other activities like if you innovate something and if you want to protect or if you want to get it commercialized by commercial operations, then you may contact us. We take the help of NRDC. NRDC is a National Research Development Corporation and wing of Indian government. Now it is under CSIR, Council of Scientific and Industrial Research. So we will do that. Then IPR commercialization, this is IPR commercialization. Now that I have told you about the activities of NRDC, I'll tell you two short stories. These are not stories, but these are the fact. I'll tell you the leadership qualities of our leader. Leadership qualities, as you know, a person who is a leader, he has to take a vision and see how the vision and this thing and make plans how the mission and visions are fulfilled, are better realized. The first incident related to the vision and motivation of our beloved Honorable Founder President Sir. With his powerful vision, he could envisage that Amity University will become #1 research-driven university. His vision was to make Amity University a #1 research-driven university. And for his vision and motivation, you know, Honorable President Sir is an excellent motivator. If you come in touch with him, you will understand how true is what I am telling you. And for his vision and motivation, he set up NRDC, Amity, IFC much before the government policy came in being. He set up this university, Amity, this NRDC, Amity IFC in 2014. When the government of India came up with the IPR policy in the year 2016, much ahead of the government policy, we have got the NRDC Amity IFC status. And the Amity University was the first among getting the IFC status, Innovation Facilitation Center status from NRDC Amity IFC, along with AIMS and Shibpur University of Calcutta. Amity University has been recognized. You know, last year Amity University has been recognized as the #1 research-driven university because of the, you see the correlation. Founder President Sir had a vision and he implemented his vision and realized it. So far, the Indian Institute of Technology was coming as number one. And last year, we have surpassed Indian Institute of Technology and became the number one. And founder Sir Muthuji have taken the reward from the government of India, Mr. Piyush Goyal ji.
Sir,
The second story, see the powerful, how powerful the president number one is strategy. Strategy is the leadership qualities. You have to take a suitable strategy and you get it implemented. And much founder presidents are always good, and he has done it and showed it that how it is easily possible to materialize. This second story is related to the to your Chancellor, Sir Atul Chauhan, our respected Dr. Atul Chauhan ji. It was a period when Amity University, Kolkata was in the process of setting up. Dr. Atul Chauhan ji, Mr. Ramachandran and myself were working in the midnight. It was about 12:30 p.m. AM when we were working, and we are finding out strategy as assembly was going on, and in the assembly our act will come up. Amity University Kolkata Act will come up.
Dr. Yogi sir,
Pardon?
sir,
we will give a separate lecture for you when we visit. No, you can address for a long time.
Dr. Shilvamurthy.
Yeah.
Yes, I'll finish in 1 minute. Kebab,
thank you, sir.
when we were working on it, I got a call from my daughter-in-law. She was doing PhD in McGill University in biomedical technology. She said, "Dad, I passed the PhD." It was a happy news. And the second call I got from the Calcutta University. Second call I got from the assembly. My friend called me and told me that university is going to be closed for many days. So the second one, when our Dr. Atul Chauhan ji told me what happened, I said I got one good news, one bad news. And the good news is my daughter-in-law has passed the PhD. And bad news is assembly will be closed for a long time, and the Calcutta University Act will be taken in the next assembly session. But Atulji as always smiling, he says, "Don't worry, Dr. Modi, that we have got one good news from our family members. The second good news will definitely come soon." And you will not believe, within 14 days, the again assembly session was there, and then assembly session started, and in that session our act got passed.
Right.
This is the example of leader that in the situation of distress, he remains calm and quiet and as cheerful as he was. This is the motivation which we have gained. And within 14 days, our act was passed. These are the two stories. Third story, I am not telling you, Dr. Shilvamurthy, it is about.
No, thank you, Yogi sir. Thank you very much.
Thank you very much. Thank you. Wish you all the best.
Yeah.
I think I have taken little more time. Sorry.
Yeah, Mananita.
Thank you, sir. Thank you, sir, for your valuable insights, which I am sure will boost our deliberations today. Now, I would like to request Dr. W. Salvamurthy, Honorable Chancellor, Amity University, Chhattisgarh, President, Amity Science, Technology and Innovation Foundation, and Director General of Amity Directorate of Science and Innovation, and Chair Professor for Life Sciences to address this audience. Sir,
Thank you.
over to you.
Thank you very much, Dr. Monalita. A very good morning to each and every one of you who have joined us today on this beautiful morning to deliberate on a very important issue relevant to our country, which is the intellectual property rights. So Honorable Founder President, Dr. Ashok K. Chauhan, who has created this whole global brand of Amity Education Group, Dr. Atul Chauhan, the Chancellor and the President of our foundation, and the Vice Chancellor we have with us here is a very brilliant Sanjay Kumar ji, and who is a great achiever, who is giving the leadership as Vice Chancellor for the Amity University, Calcutta. And Sri Nyogi ji, a great accomplisher who has contributed to the public sector undertaking in a big way for decades, and who is the advisor, Amity Education Group, and also the Director General for Amity Humanity Foundation. And we are also joined by a very important person from GAIL, who has supported this endeavor, IPR, the sponsorship for this particular workshop. Dr. Khurana, Dr. Navjeet Singh Khurana, who is the Senior Manager Law, and Dr. Devshit Bandyopadhyaya, Senior Principal Scientist from CGCRI, which is a CSIR laboratory where Amity University has a strong MOU and doing very well. So I'm so happy to be here along with my students, who are more than 250 students. It was 280 students who have joined us today. And it is a great workshop, IPR workshop, which is very important in this new vibrant India, which is now becoming a global leader and a knowledge superpower, as Honorable Founder President Dr. Ashok K. Chauhan keeps always mentioning. Not now, 30 years ago, he predicted India will become a knowledge superpower, which is written on the walls of our sector 44 in Noida in a school. And that is how the visionary, I call him the visionary. So Dr. Founder President Dr. Chauhan, who has also joined us today, and thank you very much, Founder, for giving this global educational brand, Amity, to the whole world. Now, with regard to this workshop, India is in a knowledge era. See, all of us, we have passed through agricultural era, industrial era, information era. Now we are in the knowledge era. In this knowledge era, I will call it as a new knowledge era, because we were having a knowledge superpower. Maybe 5,000 years ago, we had Vedas, Upanishad, Bhagavad Gita, Yoga, Ayurveda, Siddha, and Nalanda, Takshila, all this existed. So we were a knowledge superpower, but we lost that glory over a period of time. So this is time for us to re-emerge as a knowledge superpower. So that is why deliberations of this type in this workshop like IPR is very, very important, because we never bothered about protecting our IPR, intellectual properties, because we thought knowledge is open. It should benefit the society. But then this culture, global culture of protecting your IPR has emerged over the decades. Now, the last couple of decades. So we have to move with the global, the trend. So we have also, the country has taken lead now. We have assumed 9th position in the whole world. India is 9th in patents. That's within a short period of time with minimal input in science and technology. That is the power of your Indian intellect. Our intellect is so powerful that as compared to anybody in the world, Indian intellect is very powerful. That is how, with a minimal 0.8% GDP input into the science and technology. And today we have been able to achieve so much 9th position, and we are moving towards the position maybe in the one among the 3rd in the world, which we will assume very soon. Amity is contributing in a big way in this mission. Amity, if you look at this, as was mentioned by both the speakers, Vice Chancellor as well as Mr. Nyogi ji, that we are #1 in the country today for the IPR. It's because of the Founder President Dr. Chauhan. For him, innovation is life, innovation is prana, innovation is breath. So this is how he has spearheaded, moved as a prime mover to see that all Amity institutions, 11 universities in India and 28 schools and 18 campuses abroad, with 185,000 students, 13,000 faculties, 5,000 PhD scholars. We are transforming all this as an innovation-driven university, research and innovation-driven university. So that is how we got the first position in the country. And Dr. Smita Sahu is currently looking after our IPR, particularly the patents, copyrights, the trademark, trade secret, and all others related to that. And in all our research in Amity, we have kept two things in mind. One is inclusivity. Our innovations have to be frugal. Whatever patents we file, IPRs we protect, that it has to be benefiting people at the bottom of the pyramid. That even the people in the lower socioeconomic strata should be able to afford the technology. So one is affordability, frugality, and also accessibility to the people at all sections. The second is sustainability, because all our research is we want to see the next generation. We have to leave a better world, a better earth, better planet. So that is how the sustainability in all our research and innovation is also a common denominator in our system. We have transferred technology, not that we have only filed patent and assumed the first position in the country, but we are translating them into product technology processes to reach out to the people. So I will give a glimpse, if I can have 2 minutes, about 10 minutes for my presentation. I thought everyone, including our chief guest, Dr. Raghavendra Ji, that we want to show you that what all Amity is doing today. Can you see the slide?
Yes, sir.
Yes, yes,
Thank you.
we can see it.
Right, thank you. He is our founder president, which everybody was mentioning, that he is a PhD in chemical engineering and who did PhD from Germany, lived in 28 years in Germany, and then he became entrepreneur. And he brought all those which he learned in Germany and Europe and other countries into India, invested in education, research, innovation, and philanthropy. And he has predicted 30 years ago that India will become a knowledge superpower, which is happening now. And the IPR workshop, IPR, which India has reached 9th position, is all an indicator. And in publication, we are number 3rd in the world. Only in Global Innovation Index, we are 46th, and we should now raise that as well. And these are the chancellors, the Amity University, Calcutta, where you are. And as chancellor is Dr. Atul Chauhan, who is also president of our foundation, a product of London Business School, and born and brought up in Germany in the early days of schooling. And also Dr. Asim Chauhan, a product of Wharton Business School. These are the people who govern, the founder president, the chancellors, and also Madam Chairperson, Mrs. Amita Chauhan, who looks after our international school.
Your slides are not moving.
Is it moving now?
No, sir, it's not moving.
Sir, can you put
It
it
is-
in the show mode?
It's stuck, sir. It is.
Sir, if you could
No,
put
it
it
is
in the
edit mode,
slideshow
sir.
mode.
No,
Yeah,
I'll share it
now it
again.
will be.
Yeah, just share the screen, sir, and if you could put it as slideshow from the beginning.
I will just reshare it. इनको बुरा ये देवेंद्र को दिया.
Right now, sir, you put it in the show
Yeah.
mode, sir.
Sir, on the top there is a slideshow option. Just after animations, there's slideshow. Just click that and say from the very beginning.
Otherwise, F5, sir.
Slideshow, yeah, or just say F5.
F5 will bring into the show mode, and then thereafter you'll be able to sequence it.
Can you see that now?
The first slide is seen, sir.
What about now? Second slide.
Sir, following slides again, it is streaming. It is not coming because some kind of
Slide
streaming is
show me.
going on.
Is it visible now?
No, the IT operator, I will request you to put, please. Yeah, that's right.
Yes.
Now it is absolutely right. Sir, it is right. Please go ahead.
Is
Yeah,
it
that's
changing
right.
now? Slides are changing?
Yes, yes, yes.
Yes.
Yes, no.
Okay, so these are the people who govern the Amity group. I'll just give a glimpse of our campuses. Each campus has got a unique architecture, landscape, and also verticals, which we have developed in different specialization. And these are campuses abroad. We have Dubai, Mauritius, Singapore, London, Romania, China, US. So our students must know you have joined this institution, which is research and innovation driven, and where all the research is focused on the benefiting the society. These are the countries in which we are, and these are some overseas campuses. We have in New York a very big campus, which is 175 acres, where we have developed a Amity Global Research Hub. We run about 300 undergraduate and PG programs recognized by UGC in various domains. You name any course, it will be there in the Amity University. We are also having all recognitions and accreditation, and which is required, not only national accreditation, and we are grade A plus given by NAC, which is a very important national agencies for accreditation. We have Basque accreditation and UK, the IET accreditation. These are very rare for a country like in Asia. And we are among the top 3% globally. And when you look at national ranking, our Amity University is 25th in the country. Yeah, university which is only 16 years young, we are now 25th in terms of the national ranking. In pharmacy, we are number 11. So all this Amity University, Calcutta is also emerging as one of the important player in the Amity group of universities, and which is emerging as a knowledge hub as well. So we are among the galaxy of these eminent people like IITs, IISc, and Hyderabad, and University of Calcutta, which these are all the very important leaders. So we are among the state private university, we are number 1.
The Indian Intellectual Property Office of the Government of India has conferred the National Intellectual Property Award 2020 on Amity University for top Indian academic institution for patents and commercialization, a reflection of Amity's commitment to research and innovation.
This is the, today we have 1,665 patents. Actually, 5 patents have increased from yesterday to today. So you will find we have 26,000 research papers in journals of repute, like Nature, Lancet, Cell, and Material Horizon, Nanoletters, RSG journals. So this is what is Amity today. And we are recognized by DSIR. We have created the necessary ecosystem and connected with all the stakeholders, universities, industries, laboratories, and the society. So we know what the society requires. So our research is focused, innovation is focused on that. Similarly, IPR protection, we have established a cell, and we have a Directorate of Innovation and Technology Transfer. DST has given us the first technology enabling center, which helps to mature the technology from TRL 1, 2 to maybe 6 or 7, so that industry can take it for commercialization. We have entrepreneurship cell. How did we achieve this? We created the best human being by bringing them from various institutions, and then senior people mixed with the young, energetic, dynamic group. Then we also connected with the intellectual resource outside. Nobel laureates, they are connected. Our faculties go and work with the Nobel laureates. And for example, Dr. Nidhi Chauhan has worked in Australia for about 4 months with the Nobel laureate. And Dr. Das has worked with a Nobel laureate in Germany. So we connect with these people, and also honorary professors and honorary doctorate holders. We connect them. So this acts like a force multiplier. So these are some of the honorary professors and adjunct professors from Stanford, Cambridge, Brown, Cornell, Kyoto, Singapore, and also Canada. So we connect with these people. Our students go and work with them. They come and mentor our students. And we have I have just put a few glimpses of some of the senior people over here. And then some youngsters, Ramalinga Swami Fellows, Ramanuja Fellows, Inspire faculties. We have more than 40 of them in our campuses, including in Calcutta. Some of them are there in Amity University, Calcutta. We have a technology enabling center, which is doing very well. And also we have an incubator, which has incubated more than 300 companies and 3,500 employments have been generated. 70 startups have come out and many of them are doing very well and prospering. These are some of those incubators who are very successful startups. And then we created infrastructure, having brought the people, created the ecosystem, then we created the infrastructure. You will see beautiful laboratory. Even if you go to Amity University, Calcutta, you will find all our laboratories are well equipped and with good infrastructure for bringing out innovation and IPR, generating IPR. Because if India has to become knowledge superpower, you have to create new knowledge, secure the knowledge through IPR, disseminate the knowledge through publication as well as education, and then apply the knowledge to create the wealth and solve the problems of the society. Then Dr. Ashok Chauhan created missions, Mission Connect. We want to connect with the people. So we have MOUs with more than 300 organizations, including industries. So this brings the Mission Connect and Mission Synergy, synergy of mind, synergy of brain. And ultimately we have very important, which only Amity has, is the mission outcome. Whatever we do, there must be a sustainable outcome, which is very important in all our endeavors. So these are some industries with whom we are connected, and industries are located in our university campus. Not that only we are connected, but we have brought industries like Tata Technologies. We have established aerospace as well as the automobile section here. And CII has established Quanser from Canada. So what we have done is we have brought, and also NRDC Amity Facilitation Center, which Dr. Nyogi is the director. And he was responsible for bringing this system. Thank you, Dr. Yogi. And then these are the MOUs, national MOUs with the organization like Indian Council of Agriculture Research, Indian Council of Medical Research, Council of Scientific and Industrial Research, DRDO labs, hospitals. So we have created this connectivity, which acts like a force multiplier. MOUs abroad, we have more than 200 international MOUs, which are doing very well, active. These are the verticals which you have created. You name anything, cancer biology, genome engineering, click chemistry. These are all very niche areas in which Amity has launched verticals and specialization. Data science, artificial intelligence, robotics, photonics, food and agriculture, very strong group. So we have created such verticals, specialization. These are some technologies which have been transferred to industry. I will just give a glimpse and conclude so that people should know that how Amity is churning out new innovation. This Rutonic is a root endophyte, which gives protection against the abiotic stress, like low water availability, salinity of the soil, alkalinity of the soil. This microbe is a fungus, root endophyte. So we have commercialized this. We have put in a reactor and multiplied and then converted into a product and then given to 5 industries have taken one technology. Agrivoltaic, where to double the income of the farmer, we have created in the same agricultural field, cultivate the crop on the ground, put the vertical poles and put slanting the photovoltaic, which will give, they harness the solar energy, which will give a double income for the farmer, 2 income, one from the crop, the other one from the solar harvesting of the energy. Biodegradable plastic has gone to an American-based company. So such innovations are happening. And also from the wastewater, we are generating electricity and remedying the quality of the water itself. Nano sponge for the industrial effluent. The post-harvest is a very strong group in our system. Then I will mention one of these is a frugal innovation for potable water. Maybe Raghavendra ji will be very happy to know that we have created a simple system to purify water. What we did, we took the pebbles, etched them to give greater porosity, impregnated the silver nanoparticles into them, and then put it in a container. So you keep dipping this in the water bath for about 2 minutes. That's the minimum retention time to kill the microbes. So this silver nano kills the microbes. The water is ready to be drink. So these are some of the innovations in the, without mask, you can do the PCB prototyping. And these are some of the LPG gas sensor. If there's a leakage, we can detect at ppb level, parts per billion level. These are herbal hand sanitizer, floor disinfectant. And we have also created a very strong international center of the post-harvest technology, strong extension activity to reach out to the people. We have the Amity Institute of Indian Systems of Medicine. In our New York campus, besides the sustainability vertical, we have also created an Indian system of medicine vertical over there. Our people are recognized as not only fellows in our own science academies, but also international academies like Royal Society of Chemistry, Royal Society of Biology. And we also have Dr. Nutan Kaushik, for example, Agricultural Leadership Award she got the recent years. So these are some recent research initiatives. During the COVID, we developed an artificial intelligence-based screening for vaccine development and repurposing of the drugs. Now the last slide, I would conclude saying that Founder President quoting, and Dr. Chauhan says, I can say with pride that my scientists, my researchers move with this confidence that they will do wonders and will add to the growth of the nation. And this will help making India not only a knowledge superpower, but also a general superpower, unquote. Now, Honorable Prime Minister, who is creating a new vibrant India, he has said that science should connect with society. This is very important. Science must meet the rising aspirations of the people. So this is what is the focus of our innovation, our IPR, what we do in Amity meets this aspiration. And in fact, the government of India appointed me as the chairman to make a national policy for the scientific social responsibility, which was pronounced by Honorable Prime Minister in the Indian Science Congress in 2007. So now the national policy is being considered by the cabinet for approval, which will be pronounced. So with that positive note, I compliment once again Amity University, Calcutta for organizing this IPR workshop, and Sri Raghavendra ji for accepting our request to be the chief guest, and also Nyogi ji for having brought this. And I compliment all the people in Amity University, Calcutta who are responsible for this event, including Dr. Ankita Bhattacharya ji and Dr. Sunil George and all others who are here and looking after this. Thank you so much, and compliments to each and every one of you, and have a wonderful, intellectually enriching this workshop today.
Thank you, sir, for your valuable inputs, which is inspiring and will guide us. Now, I would like to request our distinguished chief guest, Honorable Sri Raghavendra, Joint Secretary, Department of Justice, Ministry of Law and Justice, Government of India, to give an address to our valuable audience. I take this opportunity to welcome Sri G.R. Raghavendra, India Joint Secretary, Department of Justice, Ministry of Law and Justice. Sir is a civil servant from the Central Secretariat, 1988. At present, he is Joint Secretary, Department of Justice, Ministry of Law and Justice since January 2017. He is Mission Director for the National Mission for Justice Delivery and Legal Reforms. He is driving policy reforms for improving enforcing contract parameters under the Ease of Doing Business and E-Courts project. Earlier, he was Joint Secretary in Department of Industrial Policy and Promotion, Ministry of Commerce and Industry, Government of India, New Delhi. There, he also held additional charge of Director General, National Productivity Council, NPC, from December 2015 to May 2016. He is former Register of Copyrights of Indian Copyright Office. He played a key role in the introduction of the recent amendments to the Copyright Act 2012 and Copyright Rules 2013. He has attended many WIPO SCCR meetings and FTA negotiations as a member of the Indian delegation. He made significant contributions to recently concluded 2 WIPO treaties, namely the Beijing Treaty and Audiovisual Performances 2012 and the Marrakesh Treaty, to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled 2013. He has contributed in revision of the copyright legislation of Bhutan, Kampuchea, Myanmar, and Nepal as a copyright expert. As a resource person, he gives lectures, talks on copyrights and related rights in various international and national seminars and workshops organized by WIPO and by several law schools, universities, and institutes all over India. At present, he is pursuing PhD from GGSIP University, New Delhi. He holds several degrees and postgraduate degrees, namely MA, Developmental Studies, Public Policy and Management from Institute of Social Science, ISS, The Hague, Netherlands, MA Gold Medalist MPhil Ancient History and Archaeology from Osmania University, Hyderabad. He was a GRF scholar of UGC as well. Sir, we'd like to have your valuable inputs in this August gathering, which over to you, sir.
Raghavendra ji, welcome, and you are such a great academician as well. So many degrees.
I'm still a student. I'm just pursuing my PhD in intellectual property.
We are proud to
Thank
have
you,
such.
Dr. Kundu. Vande Mataram. Good morning to all of you. And at the first instance, my apologies for joining late. And Dr. Sanjay Kumar ji and Dr. Salvamurthy ji and Dr. Niyogi and Dr. Sunil and Dr. Kundu, Dr. Ankita ji and Mr. Dr. Vishal and all the distinguished members who are attending this panel. And I would like to congratulate Amity for holding this IPR workshop. And it's really mind-boggling. I didn't aware the spread of Amity University all over the world. It is a kind of a positive Amity colonialism in education. And I'm really thrilled. My great respect to Ashok Chauhan ji. And now I understand why Amity is #1 private university in patent filings. Wow. And Dr. Salvamurthy, your presentation really gave me knowledge. You know, I always treat myself as a student and a lot to learn from what Amity is doing in innovation. So no wonder India jumped from 81 rank in Global Innovation Index in 2015 to 46, jumping 35 ranks. Means institutions like Amity has contributed to that. Major contribution, I say, for India's growth. I don't be exaggerating that India will be #10 soon in a Global Innovation Index because of the efforts of institutions like Amity. And India on policy, Indian government policy to improve Indian contribution of knowledge to the world. And also India is one of the fastest growing economies. That is happening because of contribution of intellectual property rights, innovation and inventorship and creativity. This was planned. Actually, I remember when I was in DPIIT, we started this despite a lot of doubts expired by them people, that why you want to have a national IPR policy when we have all IPR legislations available. So we wanted a comprehensive policy which guides the nation, because it's in bits and pieces in the patent, copyright, design, other industrial properties or copyright and related rights. So with a motive of, this Creative India and Innovative India, this national IPR policy started. And of course, India and laws, Indian IPR laws, both industrial properties and copyright related rights, in total harmony with WTO TRIPS agreement provisions. We have utilized the flexibilities, because when our delegation was sitting and negotiating the TRIPS agreement, we saw that the balancing of IP should be respected. Right from the Berne Convention, you see the preambles of all the IP conventions, the balance is the main thing. They're not only giving protection to the creators, innovators, and right owners, also promotion of innovation and access is important to the public interest. In education institution, access is restrained. You don't prosper, and you won't be creating so many young innovators and young creators. The very article writing and publishing will be hampered if access is not given to you. Exceptions, copyright exceptions are not given to you. either for teaching, either for other educational purposes and research. So these are all important. Now the technologies are coming, facilitating, like AI algorithms, artificial intelligence. Niti Aayog has published comprehensive strategy paper, national strategy paper, that no one should be doing in silos. So entire government departments start working on their data analytics and AI together. That's what the policy paper says. Even in the justice sector, we are doing it. And during the COVID times, India became world leader in holding the online court hearings. Supreme Court itself, 1.81 lakh hearing it has done. 25 high courts has done about 60 lakh hearings. More than 10 crore hearings by district courts is possible because the e-courts project has provided all the ICT facilities, computerization of 18,735 courts, in India have been computerized. Now phase 3 will be using AI and data analytics, so that how they understand the reasons for the pendency and the best practices and other things, whether it is for the transcription, the translation, or video conferences, know the reasons for the pendency, where it is getting delayed at the investigation level. Out of 4.5 crores cases pending in India, more than 3 crores are criminal cases. So what is the problem for the criminal cases? To reduce the delays, we have introduced the e-filing. Now e-summons have become a practice during the last 2 months. 1,200 e-summons have been issued. Only in Delhi, I'm talking about. Delhi commercial courts, 22 courts. Whereas in Delhi itself, in 11 districts, there are so many number of that. You take Tisajari itself, is the largest court complex in Asia. It has more than 200 courts. So these 22 courts have set an example for others. So AI is the data is going to be innovation. In the era of technology, 4.0 industry manufacturing is happening. Now Web 3.0 is coming. When Web 2.0 came, YouTube happened, social media happened, Facebook, Twitter, sharing of videos, and user-generated content getting uploaded. Now Web 3.0 is going to do more innovations. Everything comes to finally the algorithms and data. The way you are going to do, whether it is the 3D printing or using your mobile to switch on your TV, switch on your AC, or your other electronic gadgets, when you are driving your car, when you go out, you start using this. I forgot switching off my washing machine, or fridge door is open, or AC is on. All this you will be doing. So, and this data is going to be commercialized by the manufacturing companies to know your mindset. And as per that, they start doing the sales strategies and advertisement strategies, promotion strategies. Entire data is going to be commercialized. Again, we need a data protection law that's in the parliament, again, privacy and GDPR. And COVID times, whether you have to give the secrecy of the algorithms, how these are being used on you, how the data generated by usage of COVID for getting yourself inoculated. Lot of data is coming up. So data per se is no copyright, but the way database is arranged with a minimum degree of creativity, that's what the Supreme Court in Eastern Book Depot versus DB Modak said, minimum degree of creativity, that is originality. If there is no originality, non-original databases, because you have funded crores of rupees in creating that electronic database, without originality can be copyrightable. Unlike there is a non-original sui generis database regime in the EU, they have a directives because India and other developing countries oppose a treaty for the non-original databases, because that's against the basic law of the copyright, which comes with originality. Otherwise, everything is pirated and collected because you have money or put investment. You created a database, you can't be given copyright. But that can be treated as a trade secret. That kind of regime is different. They are doing it. That's what court, citing the Supreme Court of America, the fierce publications versus ruler telephone, that concept of minimum degree of creativity with the skill and judgment, that is the main originality. Then comes when machine is creating. Recently Guardian newspaper op-ed was written by an AI machine. When an intern, a student interning there fed the data, it has written 500-word article, op-ed. So copyright should be given to whom? So I always say, as a conventional IP person, I say that intellectual property is created by human mind. So it is the human, it is the person who will get copyright or a patent, because entire IP is about personality theory, incentive theory, utilitarian theory. All these associated with encouraging human to innovate more and create more. So how can you give copyright to a machine? That's why when Dabu's application for the patent filed in UK, that was rejected, EU Patent Office rejected, US Patent Office rejected. And before all this drama came, 5 years back, I wrote on Facebook, my group called Copyright Family. Couple of people asked, I said, no, I gave this logic, only human can be given copyright. Well, human is a natural person. Machine is not a natural person. But Amity University as a legal person or a juristic person can hold patents. When Dr. Selvamurthy is creating patents and filing patents, obviously there's a contract of service. Either the researcher under him, they're doing R&D or their center. So all these patents, even though humans are created, may be created with the help of artificial intelligence machine. They must have innovated it, but who have fed the data to the machine? So that's what we say in the Copyright Act, Section 2, subsection 6 of the author, that what computer generated works. This is applicable to the patent also. The owner of the computer generated works is the person behind that computer. So you simply can't give it to that algorithm or a software as a copyright or a patent. That is wrong. Of course, two foolish acts have been done by the Australian Patent Office and South African Patent Office, granting, recognizing inventorship to that machine, just like, concept of anthropology called anthropomorphism, means non-living beings, we are treating it as a spiritual living beings and giving them patent. That is totally illogical, incorrect. But there can be a kind of joint authorship kind. So the person owned this or institution owned this can get a patent, but the machine itself per se should not be given. This has happened recently when David Slater, walking in the Indonesian jungle after fixing his camera on the tripod, a monkey called Naruto, a macaque monkey, came and took selfies. And those selfies so beautiful. When he started commercialize, and PETA opposed it, and PETA lost the case in initial court and appeal court in US, but in Supreme Court matter they settled out of court. But here again, no, monkey is not a person. So machines and animals can't be given rights. People started talking about ethics. Ethics and morals for humans, not for the machines. And we have to be very generous with animals, but they can't be given rights. That's simple. Then the last major thing I'm going to talk about, because the basic things in the workshop, the experts will be talking about all the intellectual property rights, whether the industrial property or the copyright and related rights. The policy of Government of India to promote Atmanirbhar Bharat. So intellectual property rights playing key role in that, whether promoting the startups or promoting the MSME protection with the help of NRDC. Of course, NRDC is doing a great service in India as an autonomous body under the science and technology. But a lot of focus has to be given commercialization. Simply filing 50 patents in a year and start taking a patent certificate and decorating your wall will not work. That patent has to be marketable, and that should do the public good and also contribute to the economy. Public good means that utility. I'm going and buying that equipment either for further manufacturing or for personal use, for commercial manufacturing or something. When you buy a mobile telephone, about 500 SEPs are there in that. Various patents are there, standard essential patents. No, it has been utility is there, commercialized. So commercialization will generate employment. It generates utility to the people, and it contributes to the GDP economy. If you are simply innovating it and not it is available to the public, then no use. Only it is a decorative art piece on your wall, or enriching your CV. That's all. Just like a medal on your chest. To make India an Atmanirbhar Bharat and improve the economy, government is focusing on that. One district, one product. That is the recently geographical indication model. Pick out one geographical indication from one district and give a GI tag to that. Encourage the producers and marketing of that product. India has set the target of $400 million of export. You must be knowing that India exports have grown exponentially. I remember in 2015, when I was DIPPT, we used to break our head that why our exports are not increasing. And now, despite 2-year COVID pandemic, growth has seen so much that the exports are growing everywhere in each and every product, and the intellectual property is a major reason for that. Not only the GI product, the latest information is sweet corn. India is a leading exporter of sweet corn in the world. When Western countries sit for the breakfast, from there we are starting feeding them. So that's the power of our production, our IP, our economy. I'm a kudos to Ashok Chauhan ji imagining this and visualizing this long back, setting as a goal, as a vision and mission, and achieving it. I believe that they will achieve more. And coming to another reason for this Atmanirbhar Bharat I'm talking about, remember when COVID pandemic started, 25th March 2020, we imposed first lockdown. We didn't have mask, N95 mask, suddenly started producing. No face shield or no other equipment, sanitizer manufacturing increase. So all these things and medical equipment, and it not only provided necessary arms and defense system to fight the COVID pandemic, it created economy. It created employment. People who have to close their, I watch many people, so they close their businesses, but still earning. I was wondering from where the money coming. They're supplying all these necessary arms and ammunition to fight COVID. Not only India, abroad also. And we invested in the major area we need. So why India is called pharmacy of the world? Because and our Atmanirbhar Bharat succeeded because remember those photographs or videos. Prime Minister himself twice visited Serum Institute, Bharat Biotech company, a manufacturing facility in Hyderabad, and various other facilities of pharma companies. Why? There was a need for Prime Minister himself going there. Means he was personally supervising these innovations. And we succeeded in getting a license for manufacturing AstraZeneca COVID vector-based vector-based technology is one kind of technology, vaccine technology for manufacturing Covishield in India. We were successful. Then our own innovation came, dead virus technology, that is Covaxin from Bharat Biotech. Then world started producing Pfizer and Moderna, the mRNA variety of the nuclear acid vaccine. We started our own DNA variety. Prime Minister pronounced in UN General Assembly that India is the only country which innovated and produced DNA variety of nuclear acid vaccine for COVID. No country, Zydus D COVID vaccine. And then we have our own Atmanirbhar RNA, now the RNA vaccine, and also the Carbovax tablet, which is going to be a very disruptive tablet containing COVID. So we are exporting it. But we know that there should be more manufacturing, and there are many countries we don't have manufacturing facilities, even though technology transfer happens, whether it's mRNA or vector vaccine or dead virus vaccine or DNA. Even though you transfer the technology, simply giving technology is not enough. The human resources, means scientists and other experienced people in the manufacturing and managing that. And also, of course, our Indian varieties do not need much cold storage system. Our innovations has been created in such a way, considering the investment needed in cold storage system. But in countries like India need to export to other countries also when we get a license. But does IP laws allow that? We have various flexibilities introduced in India to make India a pharmacy of the world. When British introduced patent law, it was serving their own pharma companies. They had a patent for a product and process. When India reviewed patent on the basis of suggestion from the Tekchand Committee, Justice Tekchand Committee report and Justice Anger Committee report, we said that we don't have manufacturing facilities that should be started, especially the generic manufacturing facilities, without infringing the patented technology. So we shunned away the product patent. In 1970, we had only process patent. But when 94, when TRIPS agreement came, the 1st January, it became operative. 95, India was obligated to start that production. Then we had to introduce amending the law. Then we introduced all the flexibilities, so that even though we introduced the product patent, our generic companies which have flourished, pharma company, should not suffer and close. So we said no evergreening of patent. Section 3D we introduced, and the Novartis Glivec, which was violating the 3D, we refused to give that. They went to Supreme Court, lost the case. So no evergreening of patent. Then coming to compulsory license, Bayer's next award given to Nocto Pharma. Instead of 2,80,000 for 60 tablets, they made it for 8,000 rupees in a generic medicine. Government also encouraging that. There no patent linkage. Again, in the Bayer versus Cipla case, Delhi High Court, no, you can't link the marketing approval to be given to a generic medicine, and it can't be rejected because there is already patented medicine which got the market approval. So patenting and marketing approval not linked. That's what High Court said. Now, in the Atmanirbhar Bharat, how availability of cheap accessible medicine is government of the policy. Price fixation is not controlled under the TRIPS agreement. That is the flexibility. So that is the reason why we have a national list of essential medicines where all emergency life-saving medicines are put. That government fixes the price. You can't sell in the market more than that price. So this was utilized for various medicines and equipment during the COVID times. You must have seen that special list have come out. Even the essential medicines, the vaccines and other COVID-related medicine prices were fixed. And then we have a system, most successful system which Prime Minister Modi introduced, that is the Ayushman Yojana scheme for the medicine, and also Jan Aushadhi scheme. Jan Aushadhi scheme, I was wondering, when I spent 5,000 rupees to buy medicine for my mom for 2 months medicine, then I said, why can't I go to nearby Jan Aushadhi buy the medicine? So I got that 2 months medicine in 488 rupees. All generic medicines, biosimilar, bioequivalent, and therapeutically same efficiency. And nothing wrong. Even we all buy, and then the access to cheaper medicine, effective medicine is very, very important in India. Our generic medicine is exported even in US. Out of the counter medicine, or prescription medicine, both 60% of generic medicine are Indian medicines there. That is the reason why the pharma companies are against the Indian policy, Indian patent. They say they put in, always pressurize the USTR, put in the 301 report, say that our laws are in harmony with them. So we don't harmonize our law with the US laws, but we are members of TRIPS and Paris Convention and other international convention. We harmonize our laws with that. So coming to the why do we do need a paper, India submitted a proposal to the TRIPS Council along with South Africa to waive the patents for a particular period. IP, not only the patents, entire IP, because when a medicine must be in the market, not only the medicine, associated trade secret in the marketing trade sector, that should be waived. Any trademark should be that should be waived, and copyrighted protection is that should be waived. And if medical equipment is there, design is there, again, design comes, that should be waived. So still it is going on, and there is a leaked agreement has come out that that is only limited way this waiver has to be given. The countries who are exporting only COVID, this should be given only to COVID vaccine waiver, not for all medicines. And even for the COVID vaccine, the countries which are exporting COVID vaccine less than 10% of entire world. So it's all nonsense. Everybody is upset because of this. But now India has become world leader in the manufacturing and export this COVID vaccine. Still, we need this for certain time. That's why India is pursuing this TRIPS proposal for a waiver. So this is in a brief what is happening at the current time. I can go on talking about. I don't want to disturb the sessions where individually the experts will be talking about various things. I would like to thank again Dr. Sanjay Kumar and Dr. Selvamurthy, Dr. Vishal, and everyone giving me the opportunity. Jai Hind, Namaskar. Wish you all the best.
Thank you so much, Sri Raghavendra ji. It has been the greatest pleasure for us to host you as one of the wonderful speakers, not only as a chief guest. And it is equally, we are, really having the pleasure over here to see to this an IP man. With a great sense of pride, we are saying that you are an IP man. I was just looking at all your career profile throughout the way you have contributed towards this. And thank you very much for putting this tag to the Amity, saying that positive colonial era is all being driven by the Amity University. Thanks to Dr. W. Selvamurthy, who has been spearheading this, as a president, Amity Science, Technology and Innovation Foundation. And his lead He has given you a global kind of an overview that how our foreign founder president, sir, has been given this kind of an opportunity to serve this country. Your comprehensive talk, your insightful talk, your inspirational talk will definitely go a long way among the students community and of course our teaching and non-teaching staff to understand the gravity of this IPR Act and the way you narrated the entire stories, starting from e-filing, reducing the number of cases, keeping the originality intact, utilization of all trip provisions in terms of the vaccine waivers, etc. Talking about the artificial intelligence, cloud computing, Internet of Things, and lot many facets. What one aspect which I personally liked it, and I'm sure the audience also must have liked it equally, that the Atmanirbhar Bharat, how the whole country is looking at this, the self-reliant Atmanirbhar Bharat, commercialization, and the one aspect that came out very, very brilliantly, that any kind of an IPR and the patenting should not be for the mere purpose of decorating the walls. The tagline of yours, this is not with this thing. And thanks to Dr. Selva Murthy and President Sir, whose vision has been so very, very transparent, clear, that we are looking at that every patent, whatever we are filing, hundreds of the patents we have filed it. And now today we are emerging out as the number one city in this country, where highest number of patents and commercial products. So let me assure you, sir, at this juncture, that the Amity University has been driving it so forcefully, this concept, that it is not the only filing parts. We are not in the counting the numbers. We are looking at this, how the whole concept can be converted into the translational research. And translational research means that in a fruitful commercial products which can be utilized for the growth of the society, for the downtrodden people. I will not take much of time because a lot many speakers are there, but definitely if Silamurthy sir would like to speak something, or the founder sir would like to speak, it will be the greatest pleasure to listen to all these stalwarts. Thanks a lot, Raghavendra ji. It has been really the first time I'm hearing you. I heard quite a lot, and a student IP man, I'll say, a student joint secretary, who is really at the helm of affairs, deciding lot many policies and contributing very, very significantly in the economical growth of this country. And we'll remember this figure of yours and the government, the 400 million, is the target for the exports. And we shall be committing to this vision of this, that the Amity University as a whole, marking its global presence, that will be definitely contributing to the self-reliant Bharat. Thank you so much. Thank you so much for giving such kind of a comprehensive and insightful talk to all of us.
We sincerely thank you, sir, Raghavendra sir, for joining us and gracing this occasion with your valuable insights. Thank you, sir. Now, I would like to request Dr. Shunil George, Assistant Director and Head of Institution, Amity Law School, Kolkata, to render the vote of thanks.
Thank you, Monalita ma'am. A very good morning to everyone. On this occasion of the one-day online workshop on intellectual property rights, I would first take this occasion to thank our founder president, sir, for taking time out of his busy schedule and address this gathering of students, faculty members, and other dignitaries. We would also like to thank our Honorable Chancellor, Sir Atul Chauhan, sir, for always guiding our path as we strive to paint success stories at Amity. Our Honorable Dr. Selva Murthy, sir, Chancellor of Amity University, Chhattisgarh, for addressing the students, explaining how India was a knowledge superpower and the power of Indian intellect, and also the power of Amity Education Group in India and across the world. I'm thankful to our respected Senior Vice President, Sir U. Ramachandran, sir, for his encouragement for having a plethora of seminars, workshops, and conferences always at Amity University, Kolkata. I would make a special mention and express my gratitude to Dr. Neogi, sir. This workshop has been his brainchild, and with his constant encouragement, I've been in touch with him from the very beginning. His guidance, feedback, and suggestions have helped us to make this workshop successful. I'm sure, sir, your lucid examples of patents, copyrights, trademarks, and they're also guiding us the leadership qualities of a successful leader have been an inspiration to all of us and our students. We are thankful to our chief guest, Sri Raghavendra GR, sir, Joint Secretary of Justice, Department of Ministry of Law and Justice, Government of India, for his warm presence and blessing our workshop with his kind and motivational words. The discussion was wonderfully taken through various dimensions of future of IPR in India. I am also thankful to him for highlighting the various schemes of the Government of India and how the Government of India plans to make IPR really successful for the common man. I am thankful to Professor Dr. Sanjay Kumar sir, our Honorable Vice Chancellor of Amity University, Kolkata, for addressing the students and explaining to them the implications of trademark, geographical indications, copyright, and patents. I am also thankful to Dr. Ankita Chakravarti Bhattacharya ma'am, our Honorable Pro Vice Chancellor ma'am of Amity University, Kolkata, who has been her inspiration and her guidance and motivation, and constantly strives to make all programs at Amity successful. We are also thankful to all our technical speakers who will be speaking: Dr. Navjot Singh Khurana, Senior Manager, GAIL India Limited; Dr. Debashish Bandyopadhyay, sir, Senior Principal Scientist and Head Business Development and Publication Division, Central Glass and Ceramic Research Institute; Mr. Subrat Sahu, Examiner of Research, Patents and Designs, Indian Patent Office, Delhi Ministry of Commerce and Industry, Government of India, who will be taking time out of the busy schedule to address our students and faculty members in the coming technical sessions. I'm also thankful to the various schools of Amity University, Kolkata, Amity School of Law, School of Business Management, School of Engineering, School of Biotechnology, and all other schools who with their participation has made this workshop successful. I would also like to thank our IT team for their constant technical support, which has helped us for making this online workshop successful. Last but not least, I would like to thank all our faculty members who have very actively and enthusiastically participated and helped in making this workshop successful. Thank you, everyone. We would soon start the technical session for the day. Thanks once again. Over to you, Monica.
Dr. Mononita, you can go ahead with the next
So
program.
thank you, Sanjay. Thank you. All the best.
Thank
and
you.
Thank you so much.
Thank you so much, sir. Thank you, sir.
Thank you, sir.
Dr. Mononita, you can go ahead with the next technical session one.
You need to unmute yourself.
I sincerely thank all our online dignitaries, guest speakers, faculty members, staff, and most importantly, our students of Amity University, Kolkata at this inaugural session. Due to paucity of time, we are immediately starting with our technical session one. Our noted speaker is Dr. Navjot Singh Khurana, Senior Manager Law, GAIL India Limited. I take this opportunity to introduce Dr. Khurana. Dr. Khurana is a doctorate in law and an associate company secretary, has an overall post-qualification experience of around 15 years and is currently designated as Senior Manager Law with GAIL India Limited, Maharatna Public Sector Undertaking under the administrative control of the Ministry of Petroleum and Natural Gas. Primarily responsible for handling disputes, arbitration, and court litigation, drafting and vetting of legal documents, legal opinions, and advisory, trademark and copyrights management. Also, handle various legal issues related to sale and purchase of LNG and from international market and issues related to TAPI, handle various due diligence exercises for acquisition projects, and also remain involved in various M&A assignments. Before joining GAIL, worked with Ferguson Kabi Oncology, and which had a global employee strength of 3 lakhs and 100 countries around the globe, and sale which exceeded around 35 billion euros. Sir, Khurana sir, requesting you for your valuable inputs. I would also request the audience to write their questions in the chat box at the end of the technical session one, who will have a question answer. Over to you, Navjot Singh Khurana sir.
Hi, good morning, everyone. So hope I'm audible.
Yes, sir.
Audible.
Yeah. Thank you.
Dr.
Thank
Khurana,
you
thank
so
you
much.
very much for joining us. Thank you very much for joining us.
Thank you so much, sir. Thank you so much. Thank you for inviting, sir. As you see in the map in my background, it's the honor I have. One of the biggest this public sector undertaking in India. It's actually having a global presence now. So it's GAIL India Limited. It's earlier Gas Authority of India. So it's actually in the administrative control of Ministry of Petroleum. So GAIL, we all know that it's into natural gas transmission and marketing. So I'm Senior Manager Law and working in the corporate legal department. I'm located at New Delhi, the corporate office of GAIL. So I'm handling all the disputes, litigations, arbitrations, and contract drafting and vetting. And I must admit that IPR is a very technical subject. I may not be an expert, but I have learned over my experience of last 15 years while handling trademarks and copyrights in my organization. Even in the past, also in the previous organization, also I was handling around 750 trademarks in my previous company that was a pharmaceutical company. So I know the importance of IPR and trademark, particularly in the business, and how a company and a brand is important, and what importance it holds for a company while actually when we get it registered. So what all additional rights we have after getting it registered under the law. So I have a presentation to share. So let me just share my screen. I hope the screen is visible.
Yes, sir.
Okay.
It's visible.
Yes.
Thank you. Thank you. Thank you. So it's actually at the starting slide, it's actually a beautiful plant located in Uttar Pradesh. This is a petrochemical plant we have so my presentation would be GAIL also, and how GAIL is contributing into IPRs, and how GAIL is promoting innovations which ultimately promotes IPRs also. So it's actually linked with my company. So I just start and begin with the overview of GAIL. It's actually a 37-year-old organization. It's actually not very old as compared to all other public sector undertakings like ONGC and Indian Oil and other companies, but it's a fairly new organization, but it has grown tremendously over the last 37 years. It's actually founded in the year 1984 as a government company under the Ministry of Petroleum and Natural Gas. It is the largest state-owned natural gas processing and distribution company in India. GAIL has been conferred the Maharatna status. Maharatna status has been conferred only to 10 companies till date, and GAIL is one of the Maharatna company in India. It's actually the top India has till date awarded to any organization. So GAIL is also listed in various stock exchanges like BSE, NSE, and also in London Stock Exchange. It's actually a very slim trim organization. It's having merely 4,700 regular employees, and we are having operations almost in the entire length and breadth of the country. We have 5 subsidiaries and 19 joint venture companies spread out in various cities, which are actually handling the city gas distribution. As you are based at Kolkata, you know that there is a Bengal gas company also, which has been newly formed. So GAIL is also the major shareholder and the promoter of that company, along with the state of West Bengal. So in future, the city gas distribution in West Bengal, particularly in Kolkata, will be handled by that Bengal gas company, which is being owned by GAIL only. So it's an overview of GAIL. It's actually into natural gas, city gas distribution. It has overseas presence, upstream and other products we handle. So it's just to give an overview that GAIL is handling a pipeline network of around 13,000 kilometers, and it's actually adding more 9,000 kilometers natural gas transmission pipeline in India. GAIL also contributes 3/5 of the natural gas sold in India. It supplies 3/4 of Indian fertilizer produced and 2/3 of the Indian gas-based power. GAIL also has operates 2/3 of the total CNG station in India through alliances, and it supplies gas to around 60% of the country's PNG connections. So you can see the presence and the contribution this company is giving to this nation. Overseas presence, wherein we have Myanmar and other countries also, in Russia also, and we acquired certain interest in US shale gas also, and invested in certain CGD companies in China and Egypt. And also with respect to the upstream and other products, we bought certain blocks to extract gas out of the fields. And regarding financial performance, I will not go into the details. It's actually available on public domain also. So it's actually just to give an overview that GAIL is contributing around 50 to 60,000. It's actually earning 50 to 60,000 crore sales per annum, and earning 6 to 7,000 crore profits per annum on an slightly dipped due to COVID. Every industry has been impacted due to COVID, but otherwise it's actually a booming sector. This is a pipeline network of GAIL. You can see the green lines in the Indian map. The green line denotes the pipeline of GAIL. It's actually gone to the entire length and breadth of the nation, and it's actually spreading day by day. Now I come to the topic IPRs, and I'll just begin with the subject and the definition of the term IPR, what is intellectual property. And intellectual property is a property that arises from a human intellect. It is a product of a human creation. So it's not a physical object you can see and touch. It's actually something which arises out of an intellect of a person. Intellectual property comprises of two distinct forms. Its first is the copyright, which is mostly the literary and artistic work, and so trademarks, patents, industrial designs, and geographical indications, which are industrial properties. And I'll start with trademarks. You can see various logos, and these are all trademarks starting with GAIL. This is a trademark of GAIL. Then you can see that there's the second, the little girl with a bread in her hand. It's actually Amul trademark. So these are all well-known and globally recognized trademarks, and these are registered trademarks. And just by seeing these images, you can have an impression that you are handling or you're dealing with a particular company or a product, and that guarantees their when you see that particular brand trademark. So trademark law in India are governed by Trademark Act 1999 and the Trademark Rules 2017. The head office of trademark registry in India is in Mumbai, and they have certain offices are also in. Trademark is a territorial right. So the person who has to register the trademark has to file application in a particular territory where mark registration. There are other applications also wherein you get a combination of countries. Like in Europe also, you can file a single application for multiple territories, but actually it's a territorial right. You have to file separate applications in separate jurisdictions. The duration of trademark is 10 years from the date of the filing of the application. And that doesn't mean that after the end of the period of 10 years, your trademark will lapse. You have the right to renew that trademark, and it's actually, you can say it's actually continues till perpetuity. And the only requirement is that you have to file the renewal after the period of 10 years. So you can file multiple renewals each after the expiry of 10 years, and it can go up to perpetuity. And the example is that the logo given in the bottom, actually the BAS logo, it's actually still in 6, and it's actually an alcoholic beverage in UK, the first trademark, and it's still valid. Yeah, so the definition of trademark given in our act is actually provided in section 21ZB. It says that trademark means a mark which is capable of being represented graphically, which is capable of distinguishing the goods or services of one person from the other, a packaging or certain logos and the packaging. These are the trademark registered. Sorry. Yeah, so trademark protection, you have like passing off, it's actually a common law protection you get for an unregistered trademark, even though your trademark is not file a passing off petition before the competent jurisdiction in the court, and you can challenge if you have a mark since long, then you can, based on your usage, can challenge the use of any other person of that particular trademark and file a passing off petition. And also, in case your trademark is registered, then you have the right to file an infringement petition, and the imprisonment for a term provided in the act is not less than 6 months if there is an infringement, which may extend to 3 years. And there are also monetary penalties, which actually is within 50,000 and which can extend to 2 lakh rupees. And there is certain symbols which are linked with the trademark applications and registration. You can see that the word TM, it's actually, you can, when you have filed the application for registration of trademark, which is a goods, you can use the word TM just below or above the mark, your particular mark, and use it as per your packaging. As you can see on the right hand side, there is a Starbucks trademark and the application they have filed, and they have used TM just below that mark so that they can give an impression to the worldwide people and the masses that this particular application is under registration, it's pending registration, and other people should avoid using it and filing an application for registration of it. Similarly, when you have a service mark, you you provide a service, you file a service application, and then you can have the right to use the word SM with your trademark, and that denotes that it's a service mark and it's pending registration. And when your mark gets registered, you have the right to use R within a circle, and that denotes that your mark is registered, and that gives a warning to the third person that they should not use it, and it's a registered mark, belongs to a particular entity or an individual, and in case they will use it, then there are criminal and civil liabilities involved. These are the trademark classification as per the NICE agreement signed in France, NICE city. So these are the classification. This classification is followed worldwide. So there are 34 classes provided for registration of trademarks and goods. So whenever you file a trademark application, you have to identify your particular mark in a particular class and apply for a particular class. In case you want to, in case you have a pharmaceutical product and you want to file an application to register your trademark as a pharmaceutical product, then class 5, you can see it's a pharmaceutical class, then you have to file your application in that particular class only. There is an option for filing application with multiple classes also, in case your product deals with different classes and it actually falls into different classification, then you can file application in different. In a particular class, you get a protection only in respect to that particular class only, and the other people and use that particular trademark in other classes. Similarly, from class 35 to 45, these are service classes, and these are the services, not the goods, for which the person and entity can. So, why trademark is it prevents unfair competition by protecting the logo, brand name, and it enables the proprietor of a trademark to develop good. In the first slide, there was different logos. Over the period has developed goodwill for the brands. You can see a Maggie. Maggie is the trademark, and we have seen over the period of last 30-40 years that brand has grown too much, and that has been recognized worldwide, and people know Maggie as a product, and that is actually a trademark for noodles. So whenever the company Nestle, which is manufacturing it, they will, whenever they in future they will decide to change its name, then that will be a huge goodwill lost to them, which they have developed over the period of last 30-40 years. And now people just ask and buy product with the name of Maggie only. They do not know whether that has been manufactured by Nestle or any other company. Say they only know Maggie, and that is what a trademark can provide to a particular entity or individual. In addition to injunction, trademark owner can claim damages also. They can claim fines, legal expenses upon infringement. So a suit can be filed. A trademark owner obtains, as I just said, that your registration, you have the registration, and that prevents the defense of innocent infringement. So the general public are aware that this particular trademark is registered, so they avoid getting into that trademark and filing a similar visually or phonetically similar trademarks, and that provides a protection to the trademark owner. This is a survey which was conducted, and this provides a value what a trademark provides to a brand. So you can see in different industry, a trademark provides a different value to the business. In industrial sector, you can see that only 10% value a trademark denotes to an entire industry. Since the industrial sector requires more intensive capital infusion, and like Gale only, though we have a Gale trademark registered with us, but that doesn't denote a huge value to the company. It's merely, I think, 5 to 10%. But there are other capital which were infused by the organization. But that varies with the sector. So in case of a financial services and automotive sector, it's around 40%, which the total value of the firm vis-a-vis the value of the brand. And whenever you go towards the luxury sector, then the value of the trademark is tremendous. People buy your product based on your brand only. So whenever you change the name of the brand, your goodwill, your profits, your sales drastically reduces. So in the luxury sector, the brand value denotes around 70 to 90% of the value of the firm. Now I come to the other IPR, that is patents. So what is a patent? A patent is a statutory right for a limited period of time granted by the state in its territory to an inventor. So all the words are important. in the recognition of his invention and consideration of his disclosing the invention fully to public. So patent is a statutory right, we all know. So it's granted by the act and by the law, and it's granted by the state. It's a particular territorial right. So in India, the Indian government provides this and grants the patent to an inventor who has actually invented that in patent for his invention, and it's actually a consideration that that inventor will disclose this invention to the public so that the public will get the benefit of that invention. So the inventor will get the protection that nobody else will use that patent for a period of 20 years. That is the term of the patent. And in consideration that the inventor has to disclose and bring that patent fully to the public. And it's actually governed in India by Patent Act 1970, and the rules govern it is the rules 2003. The head office of patent in India is in Kolkata, and the branch offices are in Delhi, Mumbai, and Chennai. The conditions required for patentability are these. The patent should be novel. Whenever the inventor wants to file an application for registration or a grant of patent, the patent should be novel. That means that it should be new and not disclosed to the public anywhere in the world. The second requirement is that it should be non-obviousness, that it should not be obvious in a particular area where that patent has the wheels, that is very obvious invention, and anybody who is actually skilled in carpentry can anticipate this kind of invention. So it's nothing obvious about it's very obvious about it. Should be a non-obviousness when you file in patent application. And the patent and then invention should have an industrial applicability. It should be capable of being made or used in an industry, and it should have economic significance. So why to stop others from copying, manufacturing, selling, and importing your creation, devoid your permission. So you have the right to license your patents to the third party for their use. You can sell your patent as an asset. So you have all the right when you have a granted patent, but till the date you have the granted patent with you, you have the right to stop others. Nobody else can copy your patented invention. Nobody can manufacture it. They cannot sell it, import it in a territory where a patent is granted. So that is the right which patent law provides to an inventor. Patents give valuable guidance for planning, research, and development. So that is something very, very important to understand, that patent requires an novel idea and a research on a particular product or a process. So in an industry like pharmaceutical and other industries, which are research-based industries, they have to spend tremendously in the research and development. And till they have the guarantee that their money spent on that research will be will fetch any returns in future, they will not indulge into such kind of expenditure. So patent actually gives a guidance and a motivation to these sectors, that when they come out with a product granted a patent, and that will bring some new innovation in the sector, and which will be beneficial to the industry and to the people and the masses, then the patent law actually gives that protection to them and give motivation to them that they can spend that money, and then their invention and patent will be protected from being copied, and they particular money, and they can fetch that capital and the expenditure incurred over the period of 20 years for which the patent has been granted. So that also gives a and patent law gives right to take legal action. You can see in this slide, this is a picture of youngest patent holder in India. His name is Hrideshwar Singh Bhati. He is nearly 9 years old when he got this invention and got this patent in his name. So age is no bar. You can just see anyone who has some novel idea, who has something which is non-obvious, can file an patent application. And he earned this patent in the year 2012 when he was merely at the age of 9. The third important IPR is copyright. Copyright is registered under the Act, Copyright Act 1957 and Copyright Rules 2013 in India. Copyright, similar to trademark and patents, is a territorial right, and work can be protected under Copyright Act whenever you actually create it and fixed it in a tangible form. And the author of the work is generally the first owner of the copyright. Copyright is given as provided for the artistic work, which includes painting, sculptures, drawings. It also provided for literary work like computer programs, which includes other literary work. It also provided for musical work, sound recording, and cinematograph films. This is the duration of a copyright protection. For the literary, dramatic, musical, artistic work, the copyright is granted, provided for the lifetime of the author, and also plus 60 years from the year of the author dies. So that is the term of the copyright protection. And for the cinematograph film and the photograph, the protection is for the period of 60 years from the year in which the work is first published. The copyrights infringement remedies provided in India is the civil remedies, wherein you can file preventive and injunctive applications and suits. Also, you can claim damages and compensation from the infringers. With respect to the criminal remedies, there is a punishment which can go up to 3 years, the imprisonment, and also there is a fine which is within the range of 50,000 rupees to 2 lakh rupees. So why copyright is to of innocent infringement. With the registration, copyright holder is entitled to the statutory damages and the attorney fees in case of any infringement. Copyright copies of your work, display your work publicly, and make derivative works as well. To be considered while you plan to register your IPR. So I have jotted down and provided 10 important points to be considered. So first and most important is to consider that where do you want to get this protection. So as I just said that the IPR are mostly territorial rights like trademark patents. Consider the market where that product you will be going to launch, the product, the service, the innovation, wherever you want to first use it, where you want to expand it in future also, you have to identify all those jurisdictions and you have to file separate applications in those territories. As I said in the beginning that there are certain territories and provisions where you can file a single application.
और जो इंजन तो मारुति का बढ़िया होता ही and very smooth also. Very smooth.
Dr. Neogi, I would request you to mute your microphone. We are in a technical session. Thank you, sir.
Thank you, madam. Thank you so much. So, yeah, so I was saying that you have to actually identify the territory where you need to protect your trademark, your patents, and in advance, you have to identify those areas and file an application so that you get your trademark or a patent register granted in all those territories, and there will be no gap or loopholes when you actually launch your product in that particular territory. So it's actually a time-taking task, although the trademark registry and the government has brought down the registration time drastically, and it's now very swift as compared to what we file application in last 10-15 years ago. Now it's very fast, the process is very swift, but still you do not want to wait. When you launch your product, you want the protection immediately, so you need to identify those areas in advance when you plan your innovation, when you come up with your trademark or brand name. So the territory identification is very important. Then you have to see that what you are going to protect, what is, whether it's a product, whether it's an invention, whether it's a brand name, whether it's a logo. So each invention, each IPR is registered or protected in different acts. The brand name, you file it as a trademark and register it in a trademark act. The invention, you file it in a patent act. In case you have a literary work, you go for a copyright protection. Similarly, in industrial design also, and for geographical indications also, there are respective acts. So you need to first identify what is your invention and what is the product or a thing you are actually going to protect. Then another important point is to conduct a search and a prior art search for a trademark application. Before filing a trademark application, you should conduct a search. Search can be conducted through the trademark IP India, the Government of India website. You can search the availability of your trademark there, and in case any similar trademark is already registered, then your application you can plan your brand name and trademark accordingly and change it accordingly, so that in future when you file it, there should not be any objection from the registry, or there should not be any opposition from the third party who is already owning that particular trademark. So filing a search and conducting a search beforehand is always recommended. And similarly, in the case of patent, you file a prior art and you check whether that particular trademark should be inherently distinctive. It should be easy to memorize and pronounce, fit the product or image of the business, have no legal restrictions, have a positive connotation. So whenever you are going to file a trademark application for registration of your brand name, for your logo, so these points should be considered so that your trademarks bring more profit and goodwill to your organization. Put in place a good information security policy and program. So it is very important when you deal with IPRs. So there should be a security policy and program in your organization. And you should not disclose the invention to anyone without an executive confidentiality agreement. A confidentiality agreement should be signed and executed before you disclose your invention to any third person, so that there should not be any theft in future. Then prohibit publication of any new ideas, concept, or design until at least a formal application has been made. So there is always a chance of theft of your ideas and brands. and concepts. So you avoid getting it published in a public domain unless and until you file an application, a formal application for the registration of that particular mark or an invention. Ensure that your employees who are dealing with you, your partners, your representatives who are dealing with you in that brand and in that invention, they understand the confidentiality obligation and they should not disclose the brand and the invention to any third person. There is also important to conduct IP audits. So I know there are many students who are logged in today of Amity. So in future, I'm businesses, there will be there's a trend of startups these days. So many students are already I came across many students who are already planning to start their own businesses as a startup entities. Government of India is also promoting startups these days. So whenever you start your business and you plan to register your trademark, your patents, so it is important to conduct regular IP audits in your firm so that the trademark, patent, all these IPRs, there are deadlines given by the authority and those deadlines should not be missed. Whenever you have to file your renewal application in certain territories, you have to file your right of you have to give the evidence. Years, like in Philippines, you have to file in the way of affidavit in every 3 years to prove that you are using that trademark. Otherwise, they struck off your trademark from their register. So you should not miss those deadlines. So it's always important to conduct regular IP audits in your firm. So all the deadlines are met. Then you have to scan the market and take proactive measures to protect your IPs. So you have to see in the market whether that particular invention or the trademark you're going to get registered is being used already or not, or whether there is a similar trademark or invention available. And also, in case you have a registered trademark and a granted patent, even then you have to, if there is an infringement, you have to immediately take an action under the law, approach the suitable courts, file an infringement petitions, and actually stop and prohibit that person and a firm to use your particular brand. That is the right. That is actually going to damage your goodwill in future in case you will not take a proactive measure. Don't overspend. That is actually we have a tendency to actually rely upon the firms, the trademark firms and the patent firms entirely for your trademark application registrations and patent application registrations. There is no problem in assigning work to them, but I'm more concerned about the overspending. When you completely rely on these firms, then then you will going to spend tremendously and there will be no end to the cost to it. You have to get involved yourself also. Now anyone who has the digital certificate with you, you can file a trademark application by yourself only. You should remain involved in the entire process in case you're filing it through any patent agent or through any firm. You should remain in contact with, remain involved in each and every process, and firstly understand the process involved in filing and registration of a trademark application and a patent application, and remain involved in the process. The entire status is available online in the website, the government website of IP India. You can see, you can track your status. You should not completely rely. So I'll stress upon on this point that you should keep your budget uh, for this particular for this head, and don't overspend on it. Now, I'll share some initiative which has been taken by the government to promote innovation and IPRs in India. There is an 16 by the government that is for the awareness generation of. Actually, there was earlier shared that there was a backlog and pendency earlier, which has been reduced a lot, and it has been brought down from erstwhile 13 months, which actually were earlier taken by the authority for examination of trade. The application filing has shot up by 40%, and even the patent application filing has been increased by 6%. There is also 50% lower charges for filing trademark application by individuals, startup, and small enterprises, which has been brought up by the government. And allowance of video conferences for hearings is also available nowadays. Start with the initiative which GAIL India Limited has taken to promote innovation and also IPRs. So you can see GAIL has a separate R&D department and a robust R&D policy and R&D plan. And very proactive with respect to its IPRs. They have a separate R&D team. It has a separate R&D policy and plan in place already. So we, as a team, the R&D team, have collaborations with major IITs in India and CSIR to foster industry academia partnership for new technology development. GAIL is currently collaborating for over 20 research projects, which are in the field of pipeline asset integration management, natural gas utilization storage, CO2 and waste valorization, and polymers, etc. GAIL has also participated in establishing a center of excellence in oil and gas at IIT Bombay, which is to actually carry out industry-related research project in the seed and mission mode. GAIL has also launched satellite surveillance portal to monitor its gas pipeline network. As you know that GAIL has a pipeline network which actually goes beneath the land, and the entire pipeline is laid down under the ground. So it's actually not visible, it's beneath the land. So it needs to be monitored through technology. And for that purpose, we have launched a satellite surveillance portal. It's actually very hazardous when you deal with such kind of product. Natural gas is a hazardous product. It's actually inflammable. It can cause blast and damages immediately. So that needs to be monitored carefully, and manual surveillance is not a viable mode. So we have taken the help of the technology and used innovation in this field. GAIL has also piloted a landfill gas project to turn the waste into gas. Now we are turning the waste, which is actually a very difficult thing to handle for any government. So there are mountains of waste. If you come to Delhi, in and around Delhi, you can see the mountains of waste which is actually generated by the domestic and industrial waste, and they are accumulating and creating a mountain. So we are trying to turn those. We are also using waste plastics and converting into fuel in collaboration with CSIR and IIT. Pipeline health monitoring robo is also being developed in collaboration with IIT-K. GAIL has also filed various patent applications, and certain patent applications in different jurisdictions are also granted to it. GAIL has also established within the organization a central suggestion scheme to promote a culture of innovation. So within the organization, we promote suggestions from the employees. So employees can give their suggestions with respect to new innovations. So they can give ideas and those ideas can be worked upon. So there is a central suggestion scheme. Ideas, the best ideas are also get awarded by CMD every year. So to promote R&D project, GAIL has allocated 1% of its reserved for promoting merely the R&D projects, which recognizes the importance of R&D to improve its technological capability. Now, I come to the startups, the GAIL startup plan. I think many students have logged in today, so they must be interested to know then that whenever they pass out from this university, so when they will plan to start their own organization, the firm, uh, as a startup, so they have the option to get finances from various organizations. GAIL is one of the organization which is promoting startup entities, and I just want to bring this information into your knowledge that there is a initiative taken by GAIL, which is Punk. You can search this tagline in Google, GAIL Punk Initiative, and you can see there is a dedicated website for this purpose. And various startup entities have till date applied to GAIL, and around 29 startup entities have been funded till date. GAIL has funded as an acquired equity stake in their firms, and we are also hand holding them to grow and to prosper and to bring product and value to the nation. Startups are entities working towards innovations, development, deployment, or commercialization of new product, processes, or services driven by technology or IP. Aside 50 crore rupees just to help the new entrepreneurs to realize their potential. These days, this is very understand that job is not very easy to find. So and even government wants that we should not be job seekers, we should be job givers. So startup is the initiative wherein we can contribute to the nation, generate employment, and GAIL is the organization which is promoting those entrepreneurs to realize their potential. The original fund allocated was 50 crores, which was already approval of another 50 crores from the board, and till date did almost 60 crores of rupees to the young entrepreneurs to start their businesses and to bring innovations and IPs and work on those. GAIL is investing in selected startups and providing them adequate mentoring, as I just said. GAIL has made investment in significant startups. GAIL is also centers to leverage their expertise and resources. Startups and small firms IP filings recently has saw 200% rise according to the Department of Promotion of Industry and Internal Trade data. Recently, after Wipro and TCS, which is known to be the big giants, a 7-year-old startup company called Hike Limited has filed third highest patent application. This is remarkable thing to note that startup companies are doing great in its field, and they have filed so much application that they have came up as a third highest patent filing entity in India. There is a rise in IP filings which boost to boost innovation and R&D activity in the country. Thank you so much. And I just want to say that the students who are interested their businesses after their graduation and post-graduation from Amity and other university schools, they are most welcome to apply to these organization. GAIL is not the only organization. I can say for GAIL, as I'm working with it, I'm also handling startup investment agreements. That is my core area also. Many organizations had applied to GAIL for funding. So this is one giveaway from my side to the student that whenever you start your businesses and create your startups in future, you should consider these organizations like GAIL, there is ONGC, Indian Oil, NTPC, there are various organizations. You can search for their details over Google. Everything is available online. GAIL has recently closed its 7th round of funding for the startups in the month of January, and probably in future, sooner or later, we will start to get funding, and has a good idea, has an innovation and plan. They can apply. That the application will be scrutinized as per the and they will be provided equity contribution and also handholding by GAIL, and actually it's already contributed a lot. Many organizations and startup, I see that they are prospering like anything. In recently, 2 organizations, 2 startups, they have grown too much that they have been recently acquired, one by Reliance, and so we are happy that we gave them that push and impetus that they grown too much in just 1 or 2 years, and they built their brand and goodwill that these big giants are willing and have actually taken interest in acquiring their organization and brands. So thank you so much. I know I've just broadly covered. That is actually the kind of in the beginning I've said that I'm not the expert in IP. I have an overview based on my experience in this industry. I handled certain trademarks applications in the past in my organization. I've been handling with 67 countries for filing of trademark application. I've individually handled with all the law firms for this for filing and registration of trademarks. I know the importance and the value that brings that IPR brings to the organization. And there are more, I think, speakers lined up today. Those are, I think, certain scientists who are actually handling with and dealing with patent laws day in and day out. So I think this will be a thank you so much for calling me, and good day. Thank you.
Thank you, sir.
I'm Dr. Yogi speaking, and I was in your organization for about 9 years as Director HR and Law. So this.
Good afternoon, sir. Good afternoon, sir.
Good afternoon. Good afternoon. That time you were not there. I'm happy to see that very talented people like you are coming to the law department nowadays. And I thank you very much for giving an excellent presentation to the before the students as well as the faculty members. They will remember you. And I hope that you 3 years ago you came to Calcutta to give a presentation on IPR. Is it correct?
Right, sir. So
I was there, right.
Absolutely, sir. So just before COVID, I think in beginning of 2020, there was a physical session in Amity, Kolkata. So I met you there, sir. I had the opportunity to meet you in person.
Very good. You have improved a lot. The presentation you have given in Calcutta. That was good, but it is excellent now.
Thank you, sir.
So,
Thank you so much.
very good.
Thank you.
Only one question I want to ask with you.
Sir,
That you have said that you are tied up with IIT. IIT is for your research and development program.
right, sir.
IIT was earlier number one in research and development driven company. But now from the last year, Amity University has taken up that position. Though I know that you give most of the projects with to government aided IITs and all. But is there any scope for Amity University to also you can tie up with Amity University since it is now the number one driven research and driven. Then I'll talk to, if it is a scope, then I'll talk to your seniors, the CMD and directors, so
Right,
that Amity University can also take part in your research and development process.
Absolutely, sir. I think that would be the wonderful thing for both of us, for Gail also there and Amity also, in case there will be any collaboration of such kind in future. And I think the department concerned is the research and development department. So I'll definitely going to pass on this message to them so that they will contact your university.
Please pass on the message so that if they talk to me, then I'll tell them whom they should meet for this research and development tie-up.
Absolutely, sir. I'll do it.
Thank you, sir. Thank you, sir. Indeed,
That's a
inspiring.
great point, sir. And Dr. Khurana, I think the point what was told to you, it's a very relevant to us. And we are having a lot of great so far that nanotechnology is concerned, and in the gas and petroleum, this thing, the nanoparticles are going to really create a very indelible mark. So I would like that your competent authority may contact us, and definitely we'll be hosting you over here and looking at this, that how we can have a very collaborative approach in building all sorts of the our further projects and research and innovations. And I'm looking forward that maybe sometimes your higher excellence, in case if they happen to be in Kolkata, they can come and meet me also, and definitely I will like to invite them in the campus to show our facility, the great facility what the Chancellor sir and the founder sir has given. And what Dr. Neogi sir has said to you, it's a great idea. Definitely we are going to take it forward.
Absolutely, sir. So Neogi sir is first Galian, I think, then Amitian, I suppose. So he, yes. I think, I'm sure that he knows much more than I know. Actually, I'm much junior to him. So I'll know. I'm sure that that the people concerned and the management will definitely going to visit sooner or later, and they will going to definitely see your facilities and interact with you and Neogi sir and take it forward.
Sure. Thank you so much.
Thank you, Khurana sir. Indeed inspiring and motivating, and will keep us moving. There could be no better start to our deliberations with your motivating lecture, inputs, Gale startup, and promoting students for their entrepreneurship in future. I thank all the participants, and now we break for lunch. After lunch, we have 2 sessions starting at 1:30 dot. Thank you all for joining this online session. Thank you.
Thank you, Dr. Monomita ji, for wonderfully conducting this session and actually keeping everyone on silent mode till the session got concluded. Thank you so much. Thank you.
Thank you very much, Dr.
Thank you.
A very good afternoon. We are about to begin our technical session 2. We are beginning in a minute. Mr. Devashish, are you there? Dr. Devashish Bandyopadhyay, are you there?
Yes, I am here.
Okay, sir.
Yeah.
So you can switch on your video.
Right.
So welcome back after this is the post-lunch session, technical session 2. Here it includes the Q&A also. Let me introduce the speaker for this technical session 2, Dr. Devashish Bandyopadhyay. He is Senior Principal Scientist and Head Business Development and Publication Division, BPD, Central Gas and Ceramic Research Institute, CGCRI, CSIR. Let me introduce briefly about Dr. Devashish Bandyopadhyay. He is a molecular biologist, subspecialization in intellectual property rights, and has been working in the domain of S&T management, technology transfer, and S&T dissemination since 2005. With institutions under Department of Science and Technology and Council Scientific and Industrial Research of the Ministry of Science and Technology, Government of India. Most of his professional assignments are focused on fine-tuning institutional policies, frameworks, and systems to facilitate linking R&D outcomes in laboratories to a cross-section of stakeholders. His research interests cover sustainable development, public policy, and IPR governance with a special focus on cross-country comparisons of various development policy frameworks, technology transfer regimes, and innovation clusters. He also works on studying the implications of emerging IPR and technology transfer regimes on the developing countries from both the positive and negative perspectives. He has participated in a number of international policy dialogues in the field of IPR and technology-driven development. Sir, I would request you to take over this session, technical session 2, and also I would request the audience that at the end of the session, we'll have a Q&A. You can write your questions in the chat box. Over to you, sir.
Thank you very much, Dr. Kundu. So I'll just share my screen.
Sir, can you press F5? It will go into the slideshow mode.
Yeah, I'm in the slideshow mode only.
Yes.
Yeah.
Yes.
Is it visible now?
Yes, it's visible, sir.
Yes, sir.
Okay. Okay, so good afternoon to all of you. And it has been a pleasure to participate in this today's meeting. I understand that there has been several areas in which the discussions are being made over here. And I therefore chose not to speak about the patent laws or the types of drafting and other types of things, which I believe some of the speakers relate from the patent office are certainly to cover some of the major issues. So basically what I have therefore decided to speak upon is to sum the ways in which the present frameworks in which IP is governed all over the world and which India is a part, they have evolved. And given the short time, I have focused myself into essentially the healthcare application into the biological systems, which actually essentially because of these COVID times and other things, this is an area which has become particularly very relevant. So I would essentially speak mostly on this evolutionary aspects. Are my slides moving?
Yes, sir.
Yes, sir. Yes, sir.
Okay, thank you. So basically, as you all know possibly that there has been various categories of intellectual property rights with patents, copyrights, trademarks, GIs, circuits, designs, plant variety, all those things. So I would not focus today because of the short time across so many things. All of them have their own frameworks, many related, many unrelated. So essentially what I would like to focus upon only a very specific area. And of this, all of them almost, some of the key characteristics of intellectual property rights is, as you know, protects the creations of the human mind, gives a proprietary ownership to the inventor, usually for a given period of time. So it is not permanent. It works only for a certain specified period. The rights are essentially jurisdictional. So what it means is that you really cannot have an overarching sort of protection. You have to protect it individually in different jurisdictions. The rights are usually owned by individuals and organizations, and in certain cases by communities. And of course, they are associated with an element of innovation. So when you talk about healthcare and IPR, so healthcare and IPR essentially, which has got primarily the patents and these types of things which we consider. And today I'll basically focus essentially mostly on patents. So they cover certain areas of drugs and pharmaceuticals, diagnostics, vaccines, therapeutics, which has got recombinant origin, and of course, the live modified organisms which are there. Now, if you look at the origins of patenting in biological systems, actually, let me go back a little bit, older in time and the ways in which it has evolved, and eventually the ways in which more harmonization and international frameworks have evolved as a result of this, and why this has happened, what necessitated these types of harmonization. That is a few types of things which I would like to discuss in this short period. Now, many of you might have heard about this particular case, because many of you, I believe, are law students, and which Diamond versus Chakraborty. So this is actually the famous oil-eating bacterium, which was designed by none other than the person called Ananda Chakraborty. And this was one of the inventions which was during the early 1970s, very long time back, when there was a bacterium with a genus of Pseudomonas that contained at least 2 stable energy generating plasmid, and each of the said plasmid providing a separate hydrocarbon degradative pathway. So this was the invention for this particular patent. And this was assigned to General Electric Company. It contained total of 36 claims. And the claims essentially involved 3 important categories were there. The process claims for the method of production of bacteria, the claim for the inoculum comprising the carrier material, and the claim for the bacteria themselves. Now, when this Chakraborty applied for this patent in the US Patent Office, they allowed the first 2 categories but rejected the last, as the microorganisms, it was ruled, were actually the products of nature, and as such there was no element of human interventions and therefore cannot be patented. Now, the appeal against the rejection was done in the Patent Office, where the Congress extended the patent and certain Plant Patent Act was brought into the picture. I'm not going into the details of that. And essentially the contention that was there, it led to whether the to the interpretation, basically, whether the microorganism constitute a manufacture or a composition of matter within the meaning of the statute. So does a microorganism, does it represent manufacture or the composition of matter? Now, essentially, this microorganism which was in question was a new bacterium, which was markedly different from the characteristic that was anything that was found in nature. It was an organism that it did not exist per se in nature, and therefore it cannot be called a discovery, but it was a handiwork of an inventor. That was what was said. And essentially, as per the United States US statute, this was patentable under Section 101. Now, based on these, contentions in which the the litigation proceeded, this moved from the lower court to the Supreme Court of the US, and they granted the patent with a very narrow margin of 5:4. So 5 of the jury decided to grant the patent, 4 of them were against that one. So in the 5-4 majority decision, this patent was cleared and granted by the Supreme Court of the United States. Now, this particular case was probably one of the first cases where the patenting in biological systems and some of the major issues that were associated with patenting in biological systems which later would evolve into several types of patents in the new therapeutics and other things came into fore. And that was the first time in which these types of, questions and these types of discussions were taking place. These were, as you know, the older areas of recombinant DNA technology, and this is becoming more and more. In another case, which was a little more, this was in 1972, and the next case was in the 1980, when there was a case which was known as the Harvard Onco mouse, again an United States case, where in Harvard Medical School, it was the first transgenic animal, which is a genetically modified mouse that was highly susceptible to cancer. It was this organism that was created. You know that many of these biological labs, they create these types of organisms for doing several types of experiments. So this was a cancer model, which was created, a genetically modified, organism, transgenic animal, which was created in the Harvard Medical School. Now, the claim was stated like this. It was stated as a transgenic non-human mammal whose germ cells and somatic cells contain a recombinant activated oncogene sequence introduced into the said animal. So two major questions were raised for the patent system. So when this was sent for patenting, it raised two major questions. First was, should patents be granted for animals or animal varieties, particularly higher order animals such as mammals? So this part was essentially a more legal and interpretative matter, whether it is allowed under the statute, whether it is not allowed under the statute. And the second important question that was there before the patent system was, suppose it is granted, then how is the moral implication which will be assessed and how it will be handled? So when this case happened, actually this Harvard Onco mouse, in contrast to the previous case of Diamond versus Chakravarti, this had taken place, this moved into multiple jurisdictions. It was, dealt in the US, in the Europe, and well as in Canada. And very interestingly, as you will see, that they were interpreted and dealt with very differently in the United States and in Europe and in Canada. In the United States, the patent was granted. The reasoning that was given was that the claim had explicitly excluded humans and therefore addressed the ethical and legal concerns. The utility was unquestioned because this will be, it will have a major role in medical research. The European position under the UPC, they stated that exclusion of patentability for those that are contrary to the order or morality in Article 53A, that was flagged, and Article 53B, where the exclusion from patentability for animal varieties or essentially biological processes for the production of animals, these two were flagged, and these two key provisions, it was stated, was not getting satisfied over here, and this has to be addressed. And as such, it was questionable whether the patent was granted or not. And it was construed that the Onco mouse does not represent an animal variety. In contrast, what happened in Canada? So basically, the European patent finally was given, but actually there were certain issues, 5 major issues raised on the morality concepts. In the Canada, the patent was rejected by a 5-4 majority, in which the logic that was stated was that the composition of matter was understood as ingredients or substances that were combined or mixed together by a person. And the oncogene or injected egg, which was capable of producing the onco mouse, might be considered as a mixture of ingredient, but the body of the mouse was not. The majority of the view in the ruling, it stated that, this was, as you might understand, this represented a very thin line, a very thin area in the interpretation of what should be considered as moral, what should be considered as immoral, whether you really, the entire animal, can it be patented? Does the animal represent really an invention or an innovation that does not exist in nature? Or whether, since you have simply done some tinkering around with its gene, some genetic engineering changes that you have done, should it be construed that whatever the human intervention was there is related only to that and not to the mouse? And this was what was written by the jury, that it is not the task of the court to situate a line between the higher or lower forms of life. If higher life forms are to be patented, it must be under the clear and unequivocal direction of the parliament. So it gave the baton directly to the parliament, or to the legal bodies to actually determine what is to be done, to the law framing lawmakers. In contrast, the minority view, it stated that while parliamentarians did not contemplate the Oncomouse in 1869, when it enacted the definition of invention, it did not contemplate moon rockets or other things either. So basically, it was stated that since the laws or the lawmakers, which was in Canada, the parliamentary, the provisions in which it works, since it did not contemplate this type of advancement in science, therefore, it is not correct to assume that it does not give you the right to do the patenting. So it was, again, as I'm telling you, in a very narrow margin of 5:4. 5 people wanted to reject that one. 4 people wanted to give the patent, and the patent was rejected in Canada. But it was the same invention, the same Oncomouse. So what was essentially done was
I would request the IT team to please connect Dr. Devashish. There is some technical issue. Participants, kindly wait. Yes, sir.
Is it got disconnected somehow?
Yes, sir. It got disconnected. Sir, you have to again share your screen.
Just a minute. There is an issue with the internet today over here. Can you see now?
Yes, sir. Yes, sir. It's visible, sir. Kindly go ahead, sir.
Okay, sorry. So the overlap, so basically what constitutes discovery and what constitutes invention, this is something that has been one of the major conceptual issues that came up into this particular case. So where discovery, as you know, represents something that pre-exists in nature, and the human involvement is restricted is only in elucidating this phenomenon. Whereas invention, in contrast, does not pre-exist and is a creation of the human mind. So as you know, the IPR laws or the patent laws, they actually are given, they actually give you for the invention and not for the discovery. So obviously the next conceptual issues that also came was, does the genes and genetic materials, transgenes, plants, animal varieties, etc. represent either discovery or inventions? The next important issue that can be flagged and came to the fore was the very narrow definition of the inventive step. You know that maybe most of you are aware that whenever something is given or when patenting is done, it has to have 3 important criteria about novelty. It should be new, there has to be utility, and the third is the non-obviousness or the inventive step. So basic, that is, it should not be obvious to somebody who is skilled in the art. So only if these 3 criteria are satisfied, then only we can proceed, then you proceed for patenting. So here the important conceptual issue is the very narrow definition of the inventive step. Now essentially compared to several other domains of knowledge, several other domains of science or engineering, recombinant DNA methods are few, applied into a variety of circumstances. So to delineate the line about what constitutes obvious to one person and not obvious to another is something that was questioned at that time. Now, mind you, this has what I am telling now, or these both Oncomouse and the Diamond versus Chakraborty has to be assessed in the context of that time and not the context of like our understanding as it is today. So today there has been several greater advancements and greater understanding of these entire processes. But especially during those times, as I told you, during the early periods of the recombinant DNA, these were some of the very key areas where understanding had been extremely less, and understanding of the entire process has been lacking. And especially when it comes to the very boundary, which, confluence domain of science with law. The method that is used for one, another important thing was that the method that is used for one gene or organism might seem obvious for another gene or organism. So suppose you have done something for one gene, the same thing you are doing for something, some other gene, whether you will consider that inventive step or you will consider it obvious. And there it requires, therefore, a more critical redefinition of inventive step. This look for into that area. The third issue is what is that essentially biological process? Now, life form constitute an ensemble of non-living chemical compounds whose interplay actually leads to the process of life. As you know, the chemicals which comprise of the life forms are actually non-living entities. But when they keep together, when they function together as an ensemble, it finally gives rise to the life form. So genetic engineering exercises control over altering gene function through modifying several cellular aspects. So what will constitute an essentially biological process is a matter of question. And finally, a very, very important area which came, and again, both these things came into the picture. It's about the interplay of moral and ethical implications on intellectual property rights. Now, previously, when patents were being done, and patents were taking place in several types of other branches of materials or engineering or physical elements and things like that, when utility was there, that is, it is for the benefit of humankind, that you are not making something like to create an atom bomb or to blow up, making a big weapon to blow up humanity or something like that. It can be constituted that it is for utility provision is there. But the enormous amount of importance which has this ethical component, the line between ethics and law, the line between morality and law, and the line between ethics and science, these were certain areas which came into fore when these types of animal and biological system patenting came into the picture, which was not, what you call witnessed before to that extent. So the first question, a very simple question that was asked is industrial production of an organism morally acceptable? There are several dichotomy in court decisions in which to constitute which line is what is the line of this morality concept. So suppose in industrially you produce a mouse, is it acceptable? Then tomorrow if I produce say a larger organism, is it acceptable? And then maybe even at a greater stage, if you produce industrially and human being, will it be morally acceptable? Irrespective of what the purpose of that be. So now later on, we know nowadays is the pharmaceutical production issues in which farm animals are produced as bioreactors. So this eventually these types of things happen. Then you have these embryonic stem cells and other areas, but the morality component and utility component, it was felt that needed to be addressed very differently into different forms of IPRs. So these are some of the, and why I mentioned these things, that there is a dichotomy in our understanding, a lot of diversity in our understanding, and moreover, a lot of diversity in the interpretation of how these things are there across different. Now, what was felt, therefore, there was a need for harmonization of IPR frameworks. Now, there has to be, therefore, some rule, some basic framework, some basic governance structure, which will harmonize the IP frameworks across countries, across jurisdictions to enable greater understanding. However, so this was one area which was happening. Now, parallelly, several other things were happening. So parallelly, what was happening for this harmonization was in a totally different angle, different angles related to trade. There was international trade was happening, several types of trading things were happening. And when things were being bought and traded from a developed country to a developing country, USA had been raising several objections that actually people are taking away some of their innovations, re-engineering them, and in the process, they were losing a lot of royalty. So from the trade angle, from the economic angle, there was a pressure that there has to be some degree of harmonization across the international governance. So basically, that one, along with some of these types of issues which are arising and several other things which I'm not discussing here today, this gave rise to the, more or less an unanimous sort of decision, or rather an unanimous overall understanding that there is a need for harmonization of IP frameworks. So why I'm saying this thing of two different parallelly, because it is not correct to say that one of them have given rise to these things. It is a multiplicity of all these things. And finally, what happened, as I am talking about the governance framework, the World Trade Organizations, as you know, came into the existence. And the World Trade Organization actually draws from a multilateral agreement called the General Agreement of Tariffs and Trade, called the GATT. Now, I'm not going into the details of this thing. GATT is essentially a trade basic thing. And the reason, and actually the objective is to remove the different barriers of trade and make trading a more rule-based and competitive. Now, the reason why I have given an example of trade in this particular context is because technology transfer, which is taking place between countries, and as you know, international technology transfers play a very vital role in the development of different countries. Technology transfer is actually considered as a technology trade, and has got several characteristics of trade. So it is actually considered as a high technology, and it has got several characteristics of trading. And so when you consider technology transfers in between countries, it is important also to give some sort of understanding about how these types of trade barriers work and different ways in which the global trade operates. So I'm skipping this particular slide about some of the major principles of this GATT. And actually WTO, actually there are the structure, if you look at it's a very complex structure. There are 4 annexes from 1 to 4. And actually Annex 1A is there, which contains all these types of agreements. You have got an Annex 1B, which is called the General Agreement of Trade in Services. You have got the Annex 1C, which is the trade-related aspects of intellectual property rights, and 2, 3, and 4. What is important or pertinent for us over here for understanding the intellectual property regimes is Annex 1C. So the trade-related aspects of intellectual property rights, or the TRIPS, is the key governance framework worldwide that comprises, that governs IP under the WTO. And this was actually annexed to the WTO into the Marrakesh Agreement. And it came into force in 1992. So the objectives of the TRIPS is as follows. It states that the objective is the protection and enforcement of intellectual property rights should contribute to the promotion of technological innovation and to the transfer and dissemination of technology to the mutual advantage of producers and users of technological knowledge, and in a manner conducive to social and economic welfare and to a balance of rights and obligations. A very loaded sentence. So there are a few take-home points. So as I'm telling you, the purpose of TRIPS is to harmonize the IP frameworks across countries. So what is it supposed to do? Protection and enforcement of intellectual property rights. So these are the 2 important issues. So when you protect the intellectual property rights of different people or different organizations or different communities, first is protection and to enforce that intellectual property right. And why you will do that? It will contribute to the promotion of technological innovation first. So, and to transfer and dissemination of technology. So promotion, transfer, and dissemination of technology for the mutual advantage of producers and the users of technological knowledge. So as I've told you, therefore, TRIPS is something which is very, very intimately related to the transfer of technology. So the producers and users of technological knowledge, so that it gives you social and economic welfare and to a balance of rights and obligations. So obviously, every country, every stakeholder will have their own rights and own obligations that has to be maintained, that has to be respected. So this was the objective of the TRIPS. And basically, TRIPS was, I'm not going into each and every section of the TRIPS, but essentially what happens in the TRIPS is that once this is there, the WTO, what it mandated was various countries of the world which already have their patent regimes or intellectual property protection regimes. They would finally use that one or make that the baseline and makes themselves compliant with the TRIPS. So they have to fall in line with some of the provisions which exists in the TRIPS. Now, it comprises of 7 parts. Actually, if you look at the structure of the TRIPS has got 7 parts from part 1 to part 7. So the part 1 gives you the general provisions and basic principles. Part 2 gives the standards concerning the availability, scope, and use of IPRs. Part 3 talks about the enforcement of intellectual property rights. Part 4, the acquisition and maintenance and the related inter-parties procedure. Part 5 is actually related with dispute settlement. Part 6 has got transitional arrangements, and part 7 were the institutional arrangements and the final provisions. So basically, the reason why it was arranged in this way is several countries of the world had got different types of intellectual property regimes at different levels. Some were very strong, some were very weak, some were reasonably strong. Certain of the countries did not have any of them, but ultimately the WTO mandated that all of them would ultimately lead to TRIPS compliance. So basically, there needed some transitional arrangements. There were certain provisions which were given for the countries which were the least developed countries. They were given additional time to get themselves complied with the TRIPS, So several types of flexibilities and other things were given. And while understanding the TRIPS, one important thing should be kept in mind that TRIPS is called a minimum standards agreement. So what is meant by the minimum standards is that TRIPS give you some minimum level of standards which is to be maintained by the countries while protecting the intellectual property rights. That is to maintain the rights and obligation balance. But countries can also maintain, standards which are higher than that of the TRIPS. So if somebody has a little more provision, it might have actually, but there are a minimum standards which has to be given, which is provided by the TRIPS. Now, I'm just coming to some of the few areas. As I've told you, it is not really possible to discuss about the entire thing. I would read all of you who are interested. TRIPS, the entire document of the TRIPS is available free in the public domain. It is available in the internet, in WTO and in many other places. So you can simply download and go through this one, where you will understand that how these things are happening and how it has been important in shaping the global IP regimes. So please go through the TRIPS agreement if you are interested. Now, when you talk about the pharmaceutical patents, under the TRIPS gives you certain obligations for the member countries, which I would just like to touch upon. So the first one is the patentability and criterion of patentability. Another important issue is non-discrimination. Third issue is the research exemption, anti-competitive practices, compulsory licensing, parallel imports. These are some of the areas which are mandated by TRIPS in their own way, and they are eventually incorporated into the laws of the respective countries in their own way, in their laws. So basically, the TRIPS is the governance framework. Within the framework, it is not an executive framework. Final execution takes place in the country's laws. The patent law in India, it will be by the Indian patent law. In another country, it will be by their country's patent law, right? In Bangladesh, it is Bangladesh's patent law. In Brazil, it is Brazil's patent law. So the provisions which is required by the TRIPS and also the specific provisions that is required by the country has to be incorporated into the provisions under the areas. So in terms of patenting, what has been given in the TRIPS Articles 27.1 is member countries have to provide patent protection for any invention, whether a product that is a medicine or a process or method of producing the chemical ingredients of a medicine. So it has to provide the patent protection. So this is something which is mandated. The second is like the patent protection is to last for 20 years from the date of filing of the application. Now, prior to the WTO, prior to the pre-TRIPS regimes, many countries had given different levels of years of protection. But the post-WTO, post-TRIPS regime, the countries, this has been normalized and harmonized into 20 years after the filing of the application. To qualify for the patent, an invention has to satisfy the criteria of novelty, non-obviousness, and industrial applicability. This was there in all the time. And the disclosure of an invention has to be complete and should indicate the best mode. So best mode means, you know that in patent actually, when you talk about a claim or you talk about a patent, the word patent means actually I reveal. So you reveal something, an innovation which is important for humanity, important for technology progress. So you give the entire process so that anybody skilled in the art, anybody who is qualified enough can reproduce your work and do the work himself or herself. So you disclose it completely in a way so that it can be replicated. And in return to this disclosure which you are making, the particular person is given a proprietary right to use the invention for a period of 20 years. So this is actually the basic crux in which the entire patenting regime operates. So as which is the, you can understand, this is the rights and the obligation. So you get the right for using it for 20 years. Your obligation is you have to disclose it fully. So you cannot do it in a way that it is half. You will not, somebody who is working on that will not be able to do the work or things like that. Now, when I'm talking about biological science, I'm giving you what this particular article I want to mention separately, although it is not directly related to healthcare, but actually what is the member shall exclude from patentability plants and animals other than microorganisms, essentially biological processes for production of plants and animals other than non-biological or microbiological processes. So basically, now you are understanding about like how we will exclude that plants and animals other than microorganisms and essentially biological processes have been excluded from patentability under the TRIPS agreement in Article 27.3. However, but this is actually a very contentious clause because there is a lot of debate over here that however, members shall provide protection of plant varieties either by patents or an effective sui generis system or by a combination thereof. So basically that is again an area of interpretation about what constitutes an essential biological process, what constitutes a plant, what constitutes a plant variety, or in the way in which you will do. So this part is more related towards agriculture and several natural, natural resource protection IPs, which I'm not going into details today. And so now if you look at, as I've told you, that the framework ultimately gets implemented through the laws of a respective country, right? So basically, if you look at India, which actually got complied into the TRIPS slowly, that India Patent Act of 1970 eventually got into the 2005 and remaining very recently, the 2016 has come. So basically, there has been the Indian laws which have subsumed these provisions gradually into their own provisions, their own statutes. And in Indian laws, actually, Section 3D and Section 3P lists some of the non-patentable invention under the patent law. So Section 3D mentions these 4 areas I'm mentioning, is that the mere discovery of a new form of a known substance which does not result in enhancement of efficiency of a substance is not patentable. New use of a known substance or mere use of a known process is not patentable. Salts, esters, polymers, metabolites, isomers, mixtures of isomers, complexes, as you know, these are very important in terms of drugs and pharmaceuticals. Particle size shall be considered as same substance unless there is a significant increase in efficacy as a result of that. And a substance obtained by mere admixture resulting only in aggregation of properties of the components again is not patentable. So these are some of the areas which is not patentable under Section 3D. And an invention which is in effect a traditional knowledge or which is an aggregation or duplication of known properties of traditional knowledge is also put out of the patentability regime under Section 3P. So this particular thing, what I'm going back is when you are talking about pharmaceutical patenting or other types of areas. So one is the patentability and criteria of patentability is what is provided by the member countries. The next concept coming is the non-discrimination. That is, members in non-discrimination clause of actually TRIPS, the members cannot discriminate between the different fields of technology in their patent regime. So you cannot say that it has to be a uniform area of all fields of technology. So this is a way in which some level of harmonization has been maintained between technology and interdisciplinary areas. And the members also cannot discriminate the place of invention and whether the products are imported or locally produced. So this is a non-discrimination clause in the IP which is provided under the TRIPS. This one is again just I'm touching upon is about anti-competitive practices where governments and member countries can act to prevent patent owners and other holders of intellectual property rights to abuse, unreasonably restraining trade and hampering international transfer of technology. So you just cannot do, this is not the anti-dumping, you cannot really sit on certain innovations for your own thing. Compulsory licensing. Now this compulsory licensing is there in almost all countries, patent jurisdiction, laws, and this is also mandated under the TRIPS. So what it means actually? Now when the government, this is a type of a situation when the government allows someone else to produce the patented product or process without the consent of the patent owner, then it is known as compulsory licensing. It does not appear actually in the TRIPS, but instead they say it in a little different way. Now, the procedure is that there must be a reasonable cause. So basically, normally what happens, you are a patentee. So if you are holder of a particular patent, you will eventually be able to license your technology, your patented technology to somebody else, a licensee. So it will need your consent. But suppose you keep on sitting on that one and you are holding the patent of something, and your thing is required by others, people are wanting your license, but you are not giving the license, then there is a provision that the controller can order compulsory licensing. So normally the person so this is usually given, again, as I'm telling you, in a very situation where a patented product is held back by the patentee for for whatever reason it may be. And apart from that, of course, compulsory licensing is sometimes given in case of national emergencies and other types of things, which will come very soon. So there is a reasonable cause. There has to be a reasonable cause, therefore, why you want to invoke compulsory license. Normally, a person or a company applying for a license must have first attempted unsuccessfully to obtain the voluntary license in a reasonable commercial terms. So like I may have a patented technology, you may want that technology at a price or at a term which is not acceptable to me, then of course, as the holder of the patent, I have every right to say that I will not give it to you. But of course, there has to be, therefore, there has to be a reasonable commercial terms, and the entire thing there should be a reasonableness in the entire process. And if compulsory license is issued, you have to be given the necessary license fee and adequate remuneration that is given. And the compulsory license cannot be given exclusively. The patent holder has to continue to produce, and the license is usually given to supply for the domestic licensing. These are some of the typical, attributes of compulsory licensing which is given. And as I told you, there is an exception that during national emergencies or under circumstances of extreme urgency or public non-commercial use or anti-competitive practices, there is no need to try for a voluntary license. Suppose an epidemic has broken out, COVID has broken out, and as you know, several of these COVID vaccines have been held up, and many times you might have seen in newspapers, people have been talking about compulsory licensing for some of these vaccines, some of these COVID therapeutics, some of these various things. So basically, most of these cases, as you know, this has been given in voluntary licensing to several people, but these are certain apt areas where the patent infrastructure gives the option of compulsory licensing in case of national emergencies and these types of health emergencies, right? Now, in this particular context, there is a very nice case study or situation which is there where this compulsory licensing was given, and it is important. So this related again to public policy and health during the African AIDS drug crisis. Now, this was something which took place a very long time back, and during when AIDS was ravaging in those areas, I believe sometime during the late 1980s or 90s, when the crisis, this paved the way for the framework of compulsory licensing and parallel import of generic drugs. So the patent of antiretroviral combinations, which you known as ARVs, were at that time held with a few multinational companies. The drugs were priced somewhere around $10,000 per patient per year, and a fabulous cost. And Africa, as you know, was ravaged by those types of, AIDS epidemic during that time, when the Indian generic drug manufacturer Cipla offered to supply the generic version of the same drug at $350 per patient per year. Now, South Africa, during that time, there was actually a South African Medicines and Related Substances Act 1965 that was amended to enable parallel import and compulsory license to procure Cipla's product. And actually, compulsory, both of these were, in vogue, and Cipla did supply these particular generic drugs to South Africa and other African countries during this one. So this led to a lot of policy debate. And finally, there was the Doha Declaration on the TRIPS and Public Health, in which each member has the right to grant compulsory licensing and freedom to determine the grounds upon which such licenses are granted. And each member has the right to determine what constitutes national emergency. So you cannot say that every country government was given the right to determine what constitutes national emergency or other circumstance of extreme urgency in which the public health, parallel imports, and compulsory licensing will be done. The effect of the provision of the TRIPS agreement that is relevant to this is the one, the Articles 3 and the 4. Each member free to establish their own regimes without challenge, subject to the most favored nation and other types of things. So essentially, when you talk about public policy and health and IPR, compulsory licensing and some of the other provisions of the TRIPS, this had led to shaping, this was an older area of this drug crisis, which eventually led to the the shaping of the TRIPS agreement, the shaping in which the provisions of the TRIPS was dovetailed into different patent provisions in the patent laws of the various countries. This led to an overall harmonization. It led to an overall development of an ecosystem where innovations and technologies can be actually distributed across the thing in an affordable way. It had a very major implication on the healthcare systems and technology transfers in healthcare systems. Now, before Bowler, I'm just coming to one more area, is about this generic. Okay, I will just talk about the parallel import. I'm just doing it before so that it will be easy for you to understand that the TRIPS provides certain areas of parallel, something called a parallel imports. Now, parallel import, what it means is actually it refers to a product which is marketed by a patent owner or a trademark owner, and the permission in one country and imported into another country without the permission of the patent owner. So essentially, suppose a drug is patented in India and say Kenya. Now the price, for example, of that particular drug is lower in Kenya, higher in India. Now, if the company A buys the drug in Kenya and imports into India for marketing, this is what is known as parallel imports. So I think I have, you can understand. So you have, suppose, two drugs. I have a patent for one particular drug in two countries, India and Kenya. In Kenya, it is priced less. In India, it is priced more. A company buys the drugs in Kenya, imports into India for marketing. So this is a situation which is known as the parallel import. And this particular parallel import is something, as I have mentioned over here, is very important, is one of the areas of Doha Declaration, CIPLA's drugs, where it was a generic drug that was parallelly imported into the African countries to deal with this public health. The last thing which I would come over here is about the experimental use exemption, which is known as the Bolar provision. Now, this is a provision or experimental use exemption. It provides to allow the researchers to use a patented invention for the purpose of research in order to understand the invention fully for the advancement of science. So normally, let's say I have a patented invention, it is a protected one. So anybody else, as long as I am a patentee, you cannot use that one to develop that one further. It is expected that you will take the, either you license it, you buy it, or do whatever you want to do with it, so that since I am the holder of the particular rights belonging to that product. So as far as the provision, the Bolar exception allows the patented invention for the purpose of research and to be used, so that I can use a particular patented formulation, use it to develop the R&D in that area further, so that I understand the invention more fully for the advancement of science and technology. And moreover, manufacturers of generic drugs can use the patented invention to obtain marketing approval without approval of the patent owner and market the generic drugs as soon as the patent of the protected drug expires. So these are the two important areas. So it provides the boost to the generic market, and also it allows for greater development of that. So how did this Bolar provision come into the picture? There has been a long story, and it is interesting to know how this provision has evolved. The reason why, so there was originally a case which happened between Roche Products and Bolar Pharmaceuticals. And so this Bolar was actually a generic drug manufacturer who apprehended marketing of a drug that was covered by a patent, and Roche, actually another very important pharmaceutical product, was pharmaceutical industry which held the patent for that particular drug. And so once the term expired, Bolar wanted to use that formulation for the generic market. So it applied for marketing approval prior to the expiry of Roche's patents. Now, for this purpose, they had to carry out clinical trials, and for which they had purchased a small quantity of this patented product to conduct the trials. This is needed because you need to do it for the drug approval. In India, you have the DCGI. In USA, you have the FDA. So different countries have different types of approving authorities. And actually, you need to go for the clinical trial, get those marketing approvals. And what happened as a result? Roche sued Bolar for infringement. So once this case happened, the Court of Appeal rejected Bolar's defense of experimental use exemption, stating that the defendant's action was commercially motivated and was not for carrying out research. The case, and actually Bolar lost the case, Roche won the case, and however, this particular case had a very lasting impact that led to the legislation in the interest of generic drug manufacturers. So the fallout of the Roche and Bolar case, this was case happening in the United States. The US Congress, it enacted a particular law which was called the Drug Price Competition and Patent Term Restoration Act 1984, which was popularly known as the Hatch-Waxman Act. Now, this act provides for the limited exemption from patent infringement liability for those who make use of sell a patented invention solely for use as reasonably related to the development of submission of information. And the act also enabled the patent holders under certain circumstances to extend their monopoly beyond the term. As a result, so this was happening. The Hatch-Waxman Act came into the came into effect in 1984, and along with it, there was another case between Merck and Integra, in which Merck KGaA and Integra Life Sciences in the United States Supreme Court, there was a case where the use of patented drugs in activities related to the federal regulatory processes. There was another case that was going on. And here it was the concept of objective reasonableness was developed. So whether you, as I've mentioned before several times, that interpretation is a very, very important area, not only in law, all areas of law, but especially in case of this IPR, when you interpret the provision. So you need to interpret with something called an objective reasonableness, which shall balance the interests of the patent owner and the general purpose of information collection and research on the other. And as a result, Bowler exceptions came into the picture, where experiments carried out just before the expiry of the patent term to bring a new product to a market comes under this exception and does not constitute infringement. So this paved the way for several things. First, for generic manufacturers to develop the product. So generic products will be available at affordable cost all over the world once the patent term expires for a particular patented formulation. And secondly, for several types of clinical trials and marketing approvals, when you want to use some of things in the fag end of the patent of a patented formulation, these are the two important areas where Bowler exceptions are given the rights of the general, it is a more generic right or a general right given above the patent owners in order to carry out their activities. Indian patent law actually has the Bowler provisions. It is inserted as a new provisions and states that any act of making, constructing, using, selling a patented invention for purpose related to development is required. The laws of India shall not be treated as an infringement. So this one I have already mentioned, I have told you. So I think actually I have covered the entire process thing. So I'll open this thing if you have any questions. But essentially, let me tell you what I began in the very first slide about when I talk about the governance frameworks of IPR in healthcare applications. So healthcare applications are increasing worldwide. And when it is increasing worldwide, there are governance framework that needs to be evolved. And moreover, as the entire world becomes more connected through technology transfer, you are seeing in the case of COVID and all other things. So there has been the invention maybe in one particular country. You are actually using that invention in a different country. There are requirements. There are multiple countries which are working together. There are multiple domain, multiple people and multiple institutions which are working together. So what is important, more and more we are now understanding when it comes to healthcare applications, this is not only true for healthcare, true for others also. When it comes to these types of applications, it is important to have certain harmonized global frameworks in IP. So IP is actually, there are many people who have the misconception that IPR is an impeding force. IPR will hold you back. People think that if there is no IPR, the world is free, you can do whatever you want. But IPR is actually not an impeding force. You have to understand IPR is actually an enabling force. But IPR gives you a rule-based regime. It gives you a platform, a level playing field for everybody, for all stakeholders, by means of which you can actually go ahead make sure that everybody gets the benefit of technology, benefit of research, and benefit for the overall benefit of mankind. So it is important when we discuss about IPR that when we talk about IPR laws, when we want that we need to have more patents from institutions, from academic institutions, from research institutions, students should have more patents in several industries, they should have more patents. It is also important to understand what are the some of the policy bottlenecks that needs to be addressed in order that this IPR regime performs and operates in a very seamless way, in a way in which it becomes unified and harmonious through a governance framework. We already have the TRIPS in force, but there are several debates going on in the TRIPS. TRIPS itself is, some people say, biased more towards the developed countries, less towards the developing countries. There are several debates which go on in the WTO in which the TRIPS are coming. But overall, therefore, it is important and more important, which we have come into understanding, especially in terms of this pandemic and several types of healthcare emergencies, that we need to have global governance frameworks in IPR to make the world, a much more harmonious region. Thank you very much.
Thank you, sir, for a wonderful, vivid, and elaborate lecture on governance frameworks for IPR in healthcare applications. Your entire lecture gave us a vivid, wide view on TRIPS, on characteristics of IPR, healthcare and IPR, procedures for compulsory licensing, and our students will be definitely benefited from this wonderful session, technical session 2. Thank you, sir. Thank you so much. And we sincerely extend our thanks to you. We are already in time for session 3. So from here, we'll move to session 3. Thank you, Dr. Debashish Bandyopadhyay, for your inputs today. Thank you, sir. Now, I would request Mr. Subrata Shahu, if sir, you are there, Mr. Subrata Shahu.
Yes, ma'am.
Yes, sir. Sir, you can switch on your, yes. So, dear participants, we are moving to our technical session 3. To maintain our time, we have cut short a bit on the question answer session, but definitely we would make contact with Dr. Debashish Bandyopadhyay if our students are having any questions. Now, in technical session 3, we have Mr. Subrata Shahu. He is examiner of patents and designs at Indian Patent Office, Delhi, Ministry of Commerce and Industry, Government of India. Mr. Sahu has worked as an assistant professor in the Department of Biomedical Engineering at Dinabandhu Chotu Ram University of Science and Technology, Murthal, Haryana. He has worked as a food inspector in the Department of Food Supply and Consumer Welfare, Government of Orissa, currently working in the Indian Patent Office, Delhi, Ministry of Commerce and Industry, Government of India, as an examiner of patent and designs. Mr. Shahu has MTech in Biomedical Engineering from National Institute of Technology, Rourkela in 2011. He has BTech in Biotechnology from Vellore Institute of Technology, Vellore 2009. He has LLB in CCS from CCS University, and he holds a postgraduate diploma in intellectual property rights from IGNOU. Sir, I would request you to take over the session, and with a request to the participants, the audience, to write their questions in the chat box so that we can, if we have a question answer session at the end, we'll address your issues. Over to you, sir.
Thank you, ma'am. Thanks for such a nice introduction. Good afternoon, everyone. Today, I'm just going to share my view about the IPR, some of my expertise, whatever I have gained throughout the 6 years of my joining. I will basically deal with the basic IPR structure and the patenting filing regime in India. See, extensively we have been hearing from different perspective from Dr. Debashish sir and from some other people, but I will deal with some basic regime. What actually we do, how we process the your filing application. But at the end, I will again enrich you how to draft a patent, which is most important thing. For a student perspective, for a faculty member perspective, and for a research scholar perspective, I will tell you how to draft a patent. See, it's nothing but a techno-legal document Actually, 60% of your work is done by drafting a patent application only. Another 40%, it is all about the legal perspective. How we deal with sections, how we deal with all the objections that's related to section 3, section 4, and all the other aspect of Indian Patent Act 1970, right? So let me start. Yes. Ma'am, is it visible?
Yes,
Yes,
it's
sir.
visible.
Okay, okay. So I will start from the importance of IPR and its filing procedure. How actually we deal in the Indian Patent Office. Yes. So yes, then what is an IPR? So before we moving to an intellectual property rights, we will first deal with what is property. See, property may be a tangible one or it may be an intangible one. Suppose whenever we are thinking about a tangible one, it may be a movable one or immovable one. Suppose you are using a pen. See, I can say this is a movable one because I can place this one from here to there. What is an immovable property? Any property which is just kept in anywhere permanently. That's a immovable property like building, any structure which is permanently fixed on any ground. So these are different from the what we call the intangible property. Intangible property, what we cannot even touch that one. We just feel it. We can have a right on that. So such kind of things incorporated in intellectual property. As the word itself telling, intellectual, it's related to our intellect, right? It may be an industrial property or it may be any copyright and related property. If we consider the industrial property, it again comes to patent, design, trademark, geographical indication. And in copyright one, it's a bundle of right. We can say it if somebody has written a book or somebody has created an artistic work, and if somebody has created a theme over a particular movie or some a particular musical architect. So these are all the right has been provided through the Copyright Act only. So as we discussed, the intellectual property is an idea, a design, or it may be an invention, it may be a manuscript, which can ultimately give rise to an useful product as well as an application. So whenever we are providing a right to somebody else, as the Devasi sir has already told us, first of all, we need to disclose that. Until unless we're not fully disclosing something to Indian scenario as per the Indian Patent Act is concerned, you are not providing you the right. So it's just like a two-way process of give and take. So whatever you have an idea, just disclose it in a particular format. After that, we will see on the parlance of the Indian Patent Act or the different act of the IPR. Once we get satisfied, yes, it's all is fully covered up with everything, then we'll give you a right, and that right will be enjoyed by you all. So if we consider the IPR, then what are these objective of granting an IPR? First, we need to enhance the performance level of the institution, which is the most important area nowadays we are focusing. For that is only we are creating the National IPR Awareness Program under the NIPAM, under the aegis of Ministry of Commerce and Industry. Not only to give an impetus to the research level of particular institution, but also giving the reward to the people who have invented that particular invention or who have used their sweat and energy to create such kind of product, right? The second one is to give recognition and financial benefit to the effort for the creativity. See, every idea, every creativity is not fruitful until and unless you are not that bring into the market and create a lot of wealth from there. So the most important prolific aim of our invention is to get it to the market and that create the wealth from that particular thing. See, suppose you have created a product, until unless you are not protected it from some other people who might have increased that product, you are not going to get the benefit of that. So to stop that kind of infringement, you need to get a right, and that must be protected under your name only, right? For that only you need to file all those kind of IPRs. Now third, The third most important is to create a competition among the researchers, among the institution for the quality of research. Nowadays, we are asking about number of patent filing and number of patent granted. During my scholar days, actually we were discuss about how much amount of paper you have published in high impact factor. But nowadays the scenario has changed a bit. You are asking about the people how many patent you granted under your belt. So see, these kind of competition, you are just getting increased day by day, right? The next one is the first one, the technology transfer through licensing and other means. See, these are the legal instrument through which you can transfer your innovation and your idea from one person to another person. Listen, during the licensing, what we are doing, not only we transfer our idea, we also getting the reward by some kind of agreement between the both the people, right? The most important thing, which is most important thing for the objective and the main importance of IPR, the social benefit. Whatever the creation and whatever the idea we're inventing in our laboratory, it not only benefit for the society, it also benefit for all the people who are present there by and large. So these are the kind of things we must have in mind before creating an idea, before generating an idea, and before filing an IPR. Next. So under this IPR belt, we can say that patent, design, trademark, geographical indication, copyright, semiconductor integrated circuit, layout design. So these are the kind of IPR actually we deal with. See, another one is missing, two things is missing here, the trade secret and the PPVR, this is plant protection variety rights, right? These are also we are including, these are all common under intellectual property. Now, then what is different IPs in a single product? Just imagine this is a laptop, MacBook, this is a MacBook laptop. Anybody can tell me in a single product, just a second. Hello. हाँ जी, हेलो. हाँ सर, मैं आपको 2 मिनट में बात करता हूँ. Sorry sir, sorry for the inconvenience. See, anybody can imagine this is a MacBook and this is having 5 kind of IPR in a single product. Anybody can imagine. See, if we consider the LED display, you can say there is particular technology involved in the display, right? And that is protected through patent. If we consider the body, the shape of the laptop, whatever it may be, let's say square or rectangular or the different kind of labeling is there, we can come under design. You can protect through the design. Now come to, you can see the half cut apple sign. It's come under the trademark. It is also kind of intellectual property which is protected through the Trademark Act. In the same way, whatever in the inscribed form means how to use that kind of Mac laptop, that has been written in a particular format, and that the user manual can also be protected from the copyright. Now come to the inner part, the layout of the integrated circuit. The different design of circuit also that can be protected from the semiconductor integrated layout design circuit. So these are the 5 kind of IPR. Still it can exist in a single product, right? Now, then if somebody is talking about the intellectual property rights, we can say it is nothing but a combination of your resources, your brand and your labor to protect in order to get a right on the property. But the property, if we consider in different language, you can say we are not only saving the resources, whatever we have been using since our research day, the brand you have been using, the labor we have been using, we need to get a reward out of that. So it is a combination of all those things to create an IPR, right? Now come to what is important. See, IPR is nothing but we are getting a right to protect our invention, but also to exclude other from using that particular invention, right? So not only we are getting an exclusive right to exclude other without our permission, they can't use our idea, right? By the same way, we are also utilizing our idea, we are also commercializing in the market, and we are earning something. So the very main purpose of our creation of IPR to not only to protect but also exclude other. Vis-a-vis
we also utilizing, commercializing, earning a lot from our own idea or our own invention. Now, we can say for the utilization commercial point of view, it's an you can use for your own use. You may sell to somebody else, or you can license it or assign to someone else, make a franchise or make a merchandise. These are all the instruments which have been used for earning from our own IPR, whatever we have been generated in our laboratory, right? Now, we can see in different way, in different parlance of different people. For a common person, it's a matter of pride. For an academic person, it is a matter of pride. See, if somebody is getting a patent from his idea, he has been generated in a laboratory, lots of the peer group, they have been eagerly waiting. See, he has invested his time, he has using his brain in the laboratory, and now he got reward. So it is a matter of pride for academic people. But for a businessman, it's nothing but kind of commercialization to create a brand value. Why to create a brand value? To earn, to invest a lot. So in different parlance, we can say different kind of perspective of the same IPR. Now we can start one by one. What is a patent? What is design? What is trademark? I'm just giving you an overview. I know since morning a lot has been taught and a lot has been input, a lot has been inculcated in our mind. But I'm just going to give you a small perspective of the IPR, and my main focus will be how to file a patent, how to file a design application, and how to draft a patent application. This is my main objective. Now, see, as we know, patent is nothing but a sovereign, it is an exclusive right. It is an exclusive right to stop others from making, using, vending, importing, or exercise the idea without a permission. See, nothing there is a word called the world patent. No, we can't say there is a patent called world patent. See, patent is the only right given by a particular sovereignty in a particular state under his jurisdiction, under our jurisdiction. So it is a territorial right. When you are getting the patent, if you are having an invention, if you are disclosing an invention by providing the best example on your specification, and you are saying that, sir, this is the best way to explain my invention, so that any person which is average in skill, by reading your disclosure, they can easily carry out that process, right? So once you are giving a disclosure in the complete specification, after that we are giving you a right, and that right also for a limited period of time, that is for only 20 years, right? And that is only, and that right is only valid within the territory of the particular state or particular jurisdiction, right? So this IPR, this patent is nothing but a negative right, you can say. Why negative right? Because we are excluding other from using your invention, right? So that we can stop someone. Hey man, I have developed that particular idea, that invention in my own laboratory. How we can use that one until and unless you're not getting my permission. So this is a kind of right given by the government to you people only. Now, these are the famous invention. Let me say, in 1856, Judge Alfred D. Penning, a civil engineer, he just petitioned in the Calcutta that at that time the government of India, and there is nothing what they call the efficient pankha pulling machine. So this is the first invention as recognized by the government of India in 1856. And they have given a privilege, exclusive grant privilege of that particular invention. So we can see in the similar way, these are the scientists they are having a different kind of invention, which are quite famous based on their own invention, right? So these are all the famous Indian invention. If you can consider, if you can see the nano car, see, this is the brainchild of the Tata Group, and they have created a car, four-wheeler, around $2,500 US only. Anybody can imagine, less than 1 lakh, they are getting a four-wheeler. So this is nothing but the creation of an IPR, nothing but a creation of getting a patent on that particular product. Why I am telling you that particular example? Because as sir told you, IPR, whatever the right you are giving you are not only impeding you, you are just extensively providing you the right to get a say in the market, so that
not only you are earning from your own idea, but also the society getting benefit from your idea. Can anybody understand? Can anybody can think about that? Prior to 2005, within a 1 lakh, somebody can get a 4-wheeler, nano car. So this is actually the brand of the IPR only, right? Anybody can think about that. In the same way, if we go about the vaccine of the hepatitis vaccine, only 40 cents a dose product is available. And this is the Santa Biotech. They have not only getting the right over that hepatitis vaccine, they also providing that with a very less amount to the society at large also. In the same way, the Jaipur food, it's an affordable prosthetic, which has been not only getting within 28 US dollars, right? So these are kind of famous Indian invention. Now, for an invention to get patented, no need for go for any complex idea. Even very small and simple idea can be granted patented. See, the first example is a baby shower cap. See, for every baby, whenever we are putting the water over his head, he is getting irritated or she is getting irritated. So a person comes having an idea, just get a cap around his or her head so that after putting, he can easily bath. So no need to get irritated. See, the kind of idea is there, very simple idea, but it's very effective. So these kind of things are getting patented. In the same way, nowadays we are using the user interface. So anybody who is working in the computer science, they can by using the human skin or a particular small surface, they can get patented of the particular user interface. So these are kind of idea, no need to get for a complex one, even a simple idea can be granted. Now we start with the patent application filing. See, before moving to patent application filing, we need to have certain kind of documents get ready with you. Once all the document gets ready with you, now we can approach the Indian Patent Office and we can file a patent. So what are the form most important to keep in ready to get a patent? Let me discuss one by one. The form 1, form 2, form 3, form 5, form 9 and form 18. These 6 form are most important form we must keep with us before filing a patent application. Then what is form 1 is all about? See, form 1 is nothing but they will ask about the detail of the application, the detail of the applicant, its address, who are the particular inventor of that particular invention, with the proper sign, and the requisite fee you need to be paid along with form 1. So I will give you, I'll show you how form 1 looks like on my next slide. So in form 1, you need to give the detail of your application, the detail of the applicant, who are the inventor who invented that particular invention, and the requisite fee you need to pay along with form 1. Now come to form 2, which is the most important form as per the Indian Patent Act 1970 concept. Why? It's nothing but the similar way, the way we are writing a paper. Whenever we are writing a paper, what we do? We write an abstract part, we write the material method, we write the result and discussion, and finally the conclusion. So same way, but a little different format, whatever we are taking through this form 2, that is, we know that is also called as the complete specification or the provisional specification. What we need to do in the form 2, you need to provide the title of your invention, the background of the invention, what kind of drawing you are putting there, the detailed description of a drawing, the detailed description of your invention, along with the best working example. You need to provide in the form 2, so that any layman or any average person skill in art, by just going through your working example, he can generate that kind of product in anywhere, right? After that, the most legal aspect of your invention is the claim part. Why I'm saying the legal aspect? Because that is the claim part, only you are getting the legal right? Under that claim part, if somebody is coming there and he's increased that particular right, then you can say, sir, this kind of feature I have been claiming in my application, and somebody is coming in the market. Once though my patent is already granted, he not only increased that one, he also taking that particular product. out of my way. So by showing your claim, you can increase, you can go for pre-grant opposition as well as post-grant opposition, right? So these are the all the detail of form 2 you need to have before filing an application. Now come to form 3. Form 3. Why we need form 3? Suppose somebody is filing a patent in US. Same idea, same invention, and same idea he is filing in the India. So suppose somebody is filing the same invention in India, then we'll ask him, you need to provide the detail of your foreign filing of your same invention. Until unless you are not going to give your form 3 by showing that yes, same product I also filing in US Patent Office, we are not going to process your application in a comprehensive way, right? Now come to form 5. See, form 5 is most important for those applicants who are not only investing their resources for somebody else to do on research. Let me give an example. Suppose MIT Kolkata University is giving his resources to, let's say, particular laboratory, let's say engineering department. Okay, so there are 4 or 5 faculty members who are using the resources of MIT University, and they have generated a product, right? After generation of that product, now they want to file a patent. Okay, so at that point of time, what they will do, the MIT University will become the applicant of that particular product, and those faculty members who are worked on that particular product are become the true and the first inventor, right? So that is clear. Now the onus comes to MIT University. MIT University must sign form 5, putting his signature as the applicant, and must declare that person A, B, C, D, these person are the true and the first inventor, though they have used my resources in the particular laboratory, but they have invented that particular product. So it is nothing but a declaration of inventorship by the applicant. As example, I cited the MIT University for those of the professor, right? So that is the form 5 they need to file. Now come to form 18. Form 18 is nothing but the request of examination. See, once you are done with form 1, form 2, form 3, form 5, all those documents now you have ready with you. Now it's time moves to Indian Patent Office. Just file it there and just wait for your publication. Okay. So actually there is 2 kind of provision already available in Indian Patent Office as per Indian Patent Act 1970. You need to wait for 18 months. After then your patent get published in the Indian Patent Office journal that has been published for every Friday throughout the year, right? So either you can wait for 18 months, then after 18 months, your patent get published, the application, not the granted one, the application get published. After the application get published, now you need to file form 18 for the examination of that particular application. That is the one provision, right? Suppose somebody comes to me and he or she said, sir, I have just filed an application form, but I want to get published my application very fast. Then I can say, yes, sir, there is a provision also available in Indian Patent Office as per Indian Patent Act 1970. You just file form 9, that is for the request for early publication. Within a month from date of your filing of form 9, your application get published in Indian Patent Journal that has been published in the Indian Patent Office, right? So you are having 2 kind of provision there. See, after publication, now you need to file form 18. Don't wait for 48 months, though we are providing you 48 months. Don't wait for 48 months. Just file that application form request for examination, that is form 8, so that your process getting started. See, this is nothing but a queuing process. Whatever the application got queued, just like what getting a ticket in the movie hall, in the same way the process, fast come first service basis, here we are providing. So just file the form 18. So these are kind of form you must have with you before filing a patent application. Now, see, what is the fee structure? Prior 2021, if an applicant, which is a very large entity or any institution, they need to pay around 42,000 to complete a patent application. But after we just amend our act as per the suggestion and under the chairmanship of our Honorable Mr. Piyush Goyal ji, we have not only reduced the fee to 1/4 level, that means we have reduced to 80% of fee. Now it will be what we did for a individual person as well for an institution. Now the fee is 5,600 only. With 5,600, anybody or any institution can file for Indian patent application, right? Now, then what is the filing procedure? Either you can file through physical filing mode, or you can file through portal, through e-portal mode. So this is actually the e-portal comprehensive e-filing portal, where you can get a ID, user ID, by putting all your detail. After getting your user ID, now you must have a digital signature along with you. Once you're ready with that, and once you're ready with all your document, you just upload it and you pay the requisite fee, whatever required. After filing all those fee, you just submit that particular all those document. At the very instant, a provisional application number under your title of invention will be generated for you. Now your work is over. Now the owner shifted to Indian Patent Office. On that very day, we start proceeding on your particular invention. See, there is another kind of there is another kind of thing also we are providing you as an expedited examination. See, expedited examination means, see, initially you are taking 3 to 4 years to grant a patent, because we have shortcoming of our human resources. We have very large amount of patent application just gathering there. But after 2016, we have not only modified ourselves to include more and more human resources, as well as we smoothline the whole process. Along with that, we provide the people with a one kind of advantageous opportunity to file an expedited examination. Means your examination will be examined in Indian Patent Office with very priority basis. So on that priority basis, who will be the beneficiary of the expedited examination? These are the startup, the small entity. For an applicant, if the applicant itself is a female, or for a joint applicant with other natural person where the applicant itself is a female, or any government institute or government establishment or institute, or whenever you are filing a PCT application and you are choosing India as a international search agency or international preliminary examination authority, or any agreement between Indian Patent Office and a foreign patent office, just like the JPO, whatever we are working in the Japan Patent Office. So these are the people who can choose their application and expedite examination, and they can pay the requisite fee by filing the form 18A along with rule 24C. We can proceed with that, and that can be generated, and that can be examined in a very fast manner, right? So this is all about the patent filing procedure. If we see that patent filing procedure is nothing but all about the filing all those documents. See, another thing I want to say here, the provisional specification and the complete specification. Suppose now somebody just comes to me and says, sir, I am having an idea. Till now, I haven't gone through it in my laboratory. I haven't generated any kind of data over my idea. I haven't worked that much, so I can find out the product. What I can do, whether I am able to file a patent, then their answer is yes. If you have an idea, just come to Indian Patent Office, write up your idea in a single page, and you just file it as a provisional specification. After filing the provisional specification, you will having a date of priority. Means the day you file the patent application in Indian Patent Office, that day become the priority date for you as well as the Indian Patent Office only. After that date of priority, you will having 12 months of time. Within the 12 month of time, just go to your laboratory or your workstation, chalk it out, whatever work is left there, generate the data, complete the product, and again file all those data with the complete specification within the 12 months. Now your application is totally ready. Okay, so this provisional specification we are providing you, this provisional priority application we are providing you to just confirm your priority, so that nobody can take away your idea, right? See, after the complete specification, Now we can publish your application under section 11A after the expiry of 18 months, as I already told you. Whether you may prefer for filing request of early publication with Form 9, or you can wait for 18 months. After publication, now what we'll do, we will again check it out whether you have filed Form 18. If Form 18 is there, then we can search our own work, and we start doing our own work, and we just not only comprehensively examine your application, we will provide you a sets of objection to you, and that is known as the first examination report. Okay, after the first examination report, now you will now the onus again shifted to you. Now you are having a 6 month of time. Within 6 months of time, you need to file a reply on those particular objections, right? Suppose I am saying no, your invention is already published in somewhere else, or some document is already saying the particular feature of invention. Then in the reply itself you are saying, no sir, my invention is totally different from the cited art, because the kind of feature it is telling in my invention is totally different as compared to the other cited art, because the efficiency is different, the kind of product is different, the kind of parameter I am taking during my research is different. So you need to show them by proper writing way. So once we got your reply, again we go through your reply. If still we are not satisfying with the reply, again we will give you a date of hearing. Nowadays, through video conference, we are providing the one date of hearing. On that particular hearing day, again we both will discuss. Again, you need to convince us how your idea is totally new and totally different from the idea that has been already published in somewhere else. At that time, if we get convinced, then we will grant you patent. But still you are not convinced your idea, then what will reject it, right? So this is the whole gamut of our Indian patent procedure, right? Now come to, let me tell you the screening and classification of application. Two things we must keep in mind. If anybody who is working on any defense material or any atomic energy material, so if anybody working on particular laboratory and that is using any defense material, any atomic energy material, that prior granting a patent or prior examining your application, we need to get a permission from the Ministry of Defense as well as the Ministry of Atomic Energy. Until and unless you are not getting a prior permission from both the people, both the ministry, you are not going to proceed. For that, we need to wait for another 6 months. Within the 6 months, both Ministry of Defense and the Atomic Energy, they just intimate us that no, you can proceed on that particular application. That is not in our interest. Once we got the confirmation from both ministry, then we start proceeding with examination of your particular patent application. Now, so these are the examination procedure, whatever I am telling on that particular flowchart. So these are all the technical invention, technical objection. So yes, now just have a particular idea on that particular timeline. As I already told you, you have already filed an idea in the patent office, then you are having a 12 month of time to complete that particular idea and submit the complete specification in Indian Patent Office. Now, as I told you, though you are having 48 months for request of examination, but don't waste your time. The day you are filing your patent application, I just encourage you to file the request of examination the same day itself, so that you will not get wasted your time, right? Now the reply for your set of objection is 6 months. Form 3 is for also 6 month time you need to file. Form 5 you need to file within 1 month. So these are the most important timeline we need to keep in mind. So that is all about the patent aspect of Indian Patent Act 1970. Now come to design. Okay. So what is an industrial design? Actually, the industrial design are governed with the Design Act 2000, along with certain kind of amendment rules starting from 2001 to 2021. In the latest, we are just governing with the design rules, which are amended in 2021, right? Now, what is design? Design means not only the features of shape, configuration, the pattern of ornament, composition of line, color, applied to any article, whether it may be 2-dimensional or it may be 3-dimensional, by any industrial process or means, It may be either manual way or maybe a mechanical way or maybe chemical way on a finished article or a finished product. And that must be just appealing to your eye or solely judged by your eye. Any kind of, let me tell you one example. So suppose that is a kind of phone. The way they have inscribed the word here, you can say, no, sir, I can go for a trademark. Yes, you can go for a trademark. But suppose I want to get a design part of that particular shape on that particular mobile phone, then yes, we will say this is a 2D form. Yes, 2D form. There must be completely solely judged by the kind of work they are doing. Yes, there must be a particular kind of pattern that must be available there. The type of color or type of whatever the ornamental issues. Yes, if we find out that, then we can imbibe all those things in the design part. Again, I tell you, for patent, the limitation is for 20 years you are getting the right. But for a design part, the limitation is 10 years. Yes, it can be extendable for another 10 years after the filing of renewal fee. So these are the section. The article 2A generally deals with the article as per the Indian Design Act 2000, right? So this is the design. You can either take a right of the design of the shape of the sofa. You can call L-shape sofa. The kind of mask, the zigzag show of the mask design, you can protect through Design Act. You can take the cycle design. You can take the bottle design. So these are kind of design aspect which we can be protected through Design Act. So not only we can protect for a single article, as per section 2E of Indian Design Act 2000, we can also protect that design for a sets of articles, right? If I'm not, I'm again tell you, either you can single-handedly go for a design part on a particular article or for a set of articles, you can go there. So the filing of design application, which is very simple. As we discussed, the patent filing application is a bit clumsy. But if we consider the design application, it's very simple. See, actually the main design application, the main what is called the electronic filing is totally processing in module that has been generated in IPO Kolkata. But you can physically file the same design application in Delhi office, Mumbai office, Chennai and Kolkata, right? Then we will see what are the requisite form we need to file during filing a design application and what are the fee we need to pay. See, for design application, you need to file form 1, which is most important one. And for application fee, we need to pay 1,000 for individual, small entity, large entity, startup. Sorry, for large and small entity and startup. And other than that, 4,000 we need to pay. Along with that, we need to fill form 1. In form 1, we need to mention the application name, his details of nationality, legal status, address, everything, his signature, date. After that, you need to file 2 sets of representation. What is 2 sets of representation? This is the 2 sets of representation. See, here the applicant is asking for nothing but a teapot. In the teapot, he is giving the perspective view of the teapot. This is the single specimen you need to file. You need to tell the novelty reside, the shape and configuration of the teapot, as the applicant already decided here. In the same way, suppose you are filing design of that particular pen, you will need to write down by 2 to 3 lines where your inventory or novelty resides. You can say my novelty resides in the ball only, the steel ball. The same way, you just write it down in a single paper, give 2 to 3 photographs in the both way, in the frontal view and the both other view, put your signature there, then your file is ready. After that, you just deposit in the Indian design office, the Indian patent office itself. After that, we just examine your design application. Once it get registered, we will provide you a certificate. How a certificate looks like, you can check it here. See, in this certificate, you must have a design number, the date number, and who is the actual applicant, who is the actual owner of that particular design, right? we need to provide it through this registration certificate only. Now, the way you are published the Indian patent application in Indian Patent Journal, in the same way also we are also providing you the journal for the design application. See, this is an applicant of KL University of Guntur. They have not only they have created a design of the chest compression device for fast aid, right? So in this way, we are just providing you a what you call a particular publication in our journal in the patent office journal. You must have a journal number and particular date and what is the title of your design aspect. So these are the things actually we are providing. Now, yes, again we can say what is the term of design. It is 10 years and we can extend for another 5 years, and you can have a renewal after every 10 years, right? Now come to trademark. Trademark, see, trademark is nothing but is in any word. It can be any name, or it can be a symbol, or it can be a device, or combination of all. Why we need a trademark means it will not only provide you an exclusive monopoly over a class of goods and service which distinguish the source of your good and service from other trader. Because how we can differentiate how a Nike is different from that of Puma? See, the kind of logo, the kind of trademark they are using, or how we can distinguish a Apple phone is different from the Oppo. Because the kind of trademark, they have just taken the ownership of that particular trademark that itself define the actual source of that particular goods, right? So it will not only providing an exclusive monopoly over that particular goods, it also allows the business entity to build public goodwill and brand reputation, which is most important aspect of the trademark, to generate the public goodwill as well as the brand reputation. And it also assures the customer about the quality of good as well as service. Now see, these are the examples of the trademark. See, if we can go and see the MACD, by just seeing the simple M with the yellow mark along with the background, red background, we can say yes, this is MACD. How you can just differentiate the MACD with the Burger King? See, this is a kind of trademark, this is a trade name that had been differentiated, having a logo, or that may have a particular idea, a particular word, or that may have a both combination of word and the logo. So this all come under the trademark. So trademark also, it can be divided into collective mark, certification mark, or a tagline also can be a trademark. Shape can also be trademark. Even a sound mark can be also a trademark. So these are all the different perspective of trademark, right? So what is a good trademark? A good trademark must be inherent in nature and must be acquired in nature, right? And it should not deceptive. It should not deception. You can't say I'm having a trademark. Somebody having a trademark of Hike, and you are saying having a trademark of Nike, and you just come to office and say, sir, kindly give me the trademark on the name of Nike. So it's quite deceptive in nature as compared to the Nike. We can't give you a trademark in the name of Hike, right? So it must be inherent, it must be acquired. Now, we can clearly see what is the difference between TM and the R with the round symbol. See, any trademark which is already registered in Indian Trademark Office, you can write on that particular thing R with the round symbol. If still it is not registered or application is still pending in Trademark Office, then you can write the T and the N. So this is the basic difference of a registered trademark and unregistered trademark. Now, how to protect? See, as per patent and design is concerned, for the trademark, there is no such called you need to have a registration of trademark. No, there is no such word called you need to have a registration of trademark. See, trademark registration is optional in nature. However, the registration itself provides you certain benefits. Suppose, let me tell you one example. Suppose I have developed a mobile phone in the name of Subrat Sahu as symbol, right? If somebody else come to market with the same mobile phone and he just infringe my the S symbol and is selling the copy of that particular thing. Now I will oh, now I will approach the court. I will say, sir, I have generated product and I am selling that in particular market under the symbol of S with this kind of generating symbol, but somebody else is taking it. He's just kindly infringing me. Then the court say no. Until and unless you are not registered, we can't say it's an infringement. Yes, you can say you can get some pecuniary benefit, you can take that one. That is called passing off as per the general law of tort. We can't say it is a kind of infringement. So you will have a right, so that if anybody infringe your right, then only you can approach the court. And then only as per the Indian Trademark Act, then the court will decide what are the course of action they will have to pay, right? For that advantage only, you must register. Now come to how many years it will valid. As we compare the patent for 20 years, design for 10 years, that can be extendable for another 5 years for design. But for trademark, it is initially for 10 years, but that can be renewed for every 10 years. It can be extended for indefinitely, right? So that is having a particular benefit of a trademark, right? Now next, this is all about the trademark. Now come to copyright. See, what is copyright? Copyright is nothing but is a bundle of rights. It's an automatic rights, is an exclusive right given to creator of original work of his authorship. So that if somebody has protected an idea, so that nobody else can take away the idea, right? So this is all about the copyright. So copyright is nothing but it is the combination. And what are the criteria we need to have a copyright? There must be a creativity on a minimum podium, and the creativity must be original. And as I already discussed in the user manual of the MacBook, it must be in a fixation mode. That means it must be in written format. If all these three criteria match up, then you can protect it through copyright. And the work is already protected through copyright. Now, what are the things we can protect it through copyright? The literary work. If anybody writing a novel, writing a book, as per section 2 of Indian Copyright Act 1956, through artistic work as per section 2C, dramatic work can also be protected through Copyright Act, musical work also can be protected through Copyright Act, sound recording work also can be protected through Copyright Act, even cinematic graphic film also can be protected through Copyright Act, right? So actually, who are the actual owner of all those works? So as per section 2D of the Indian Copyright Act, for literary and dramatic work, the author will be the actual owner of the copyright. For musical work, the music composer will be the actual owner. For artistic work other than a photograph, the artist who did all those work will be the actual owner of your copyright, right? For photograph, who have taken the photograph, it is his own creativity, and he is the actual owner of that particular right. For cinematograph and the sound recording, the producer, and for other literary dramatic work, who has caused the work to be created, are the actual owner of that particular act. Now, come to copyright. As we discussed, copyright is a bundle of rights. Yes, we say, but and another aspect of the right is it is both economical right as well as the moral right. Why I am saying economical right is that because see, whenever we are writing a novel, our main approach is to take that particular novel into market, right? And we are giving that particular right to somebody else so that he can produce that particular novel in the market and sell it. So as for our legal instrument, our legal agreement, we will get some kind of royalty for each book as it has been sold in the market. So it is not only getting the right in one aspect, in another aspect we are generating the wealth by selling each product under your name by somebody else who has taken the license from you, right? So on that perspective, there is a, as per section 14, it is a kind of economic right, right? So economic right is nothing but the reproduction right, the distribution right, the right to create the derivative work as per the translation and compilation of any kind of science and cinema is concerned, right of communication to public, right? Right to public performance for any kind of right of work in public, any theatrical work. These are all used by somebody else and they're paying for that particular person who have the copyright under his own name. So this is all about the economic benefit of that particular right. Now come to moral right. So moral right generally consider two aspects. One is right against the distortion and right of the recognition, means the right to object to the work being distorted or used in context that are prejudicial to the honor reputation of the author. Suppose you have created a book or an idea which has been written on a novel. Somebody comes to market, they just change somewhere, they just distorted your work, means they take away the original value of your work. So that right is protected through right against distortion. Your integrity should be maintained through that copyright act. And another is the who is the actual author of that particular work. That's the right of authorship. That is the actual recognition is provided through the Indian Copyright Act 1956. Right? Now, the term of protection for a cinematography film or sound recording, it is 16 years from the date of publication of that particular work. For broadcasting unit, it is 5 years from the year of following the year of broadcast. But for the performance right, it is a 50 year from the year of following the year in which the performance is made. Right? So these are all the term of protection as per section 22 of the Copyright Act as Indian concern. So these are all aspects of the copyright. Then how to file a form during filing copyright. So here we need to have two things only. Form 14 along with a fee, whatever required to file. Right? What are the fee you need to do? For the literary, dramatic, and artistic and musical work, you only have to pay. You need to only pay to 500 rupees. For the artistic people, they have to file 2,000 along with Form 14. From sound recording, they have to file 2,000 along with Form 14. For cinematography, they need to file 5,000 along with Form 14. So very simple. File Form 14 along with the requisite fee. Your copyright will get registered. After get registered, then the examination procedure will start. Here what we'll do, we just take some formality check. We just scrutinize it, whether that particular work is already registered or not, whether your work is totally novel or not. If it is novel, then we just approve by the deputy registrar. And once it is approved, then we can say, yes, your work will get registered and it will get registration. You will get a registration number. But if we find some kind of discrepancy, then what we'll do, we'll do the same process as we did in the patent office. We will provide you an opportunity for hearing. You just convince us by providing the certain kind of document or evidences. Once we convince, then again it will get registered in trademark in the copyright registration, right? Now, the most important, the end part is the semiconductor integrated layout design. Suppose somebody is working on a particular instrument, any kind of electronic instrument. If somebody designing the inner aspect, yes, for the inner aspect also we are providing you a right, and that right is protected through semiconductor integrated layout design, right? Now, what is the next one? The geographical indication. What is the geographical indication? See, geographical indication is nothing but a product that have a specific geographical origin and possess quality or reputation of that are due to that particular origin. Let me give you one example. Darjeeling tea. If somebody comes to me and say, sir, Darjeeling tea is totally different from that tea we have been used in the Kodai Canal or in Tamil Nadu. Why? Because the nature of soil, the kind of environment in Darjeeling, Assam is totally different of that of Tamil Nadu. So the kind of structure of the soil, the kind of quality, the kind of environment, and under which the Darjeeling tea plantation is there, and the Darjeeling tea is growing, that having an inherent quality of that particular environment. That's why the Darjeeling tea is totally, the taste of Darjeeling tea is totally different from that of Tamil Nadu or that of Kodai Canal. So this is the actual that is the actual quality that add a value to the geographical indication of particular product. So these are the example of geographical indication: the Darjeeling tea, Makarnama marble, Ratlami save, Kanchipuram seal, right? Katputli of Rajasthan, Bagh print of Madhya Pradesh, the Bengal Patachitra. See, the Patachitra of Bengal and the way of work they have been doing in the Chhattisgarh is totally different, right? The Cherial painting, if we consider the worldly painting, the ethics and the essence of the painting of both Bengal Patachitra as well as the Cherial and the worldly, all three are totally different because they have an inherent quality based on that particular culture. That's why giving an geographical indication to that particular product. Now, these are also another kind of example. If we consider the Maghai pan, the Maghai is a pan. It is generated in the Bihar district, so in Bihar instead of Bihar. And if we consider the same pan in West Bengal, in Odisha, in the Odisha Baleswar one district is there, the taste is quite different because the kind of soil in Bihar as well as in the West Bengal and in Odisha are all three are different. And then the soil and the kind of environment that add value and taste to that particular pan. That's why we are giving a particular geographical tag to that particular product. In the recently, we have gone through the Bengali Rasgulla and the Odisha Rasgulla. The one of the best, what because the famous case of the GI tag. What happened? As per the structure of the Rasgulla is concerned, the Odia people, they said, sir, this has been used as a bhoga for the Jagannath Puri Dham, right? What about the Kolkata people? What about the West Bengal people? They said, sir, the weight of sponginess and the way you are making and the way you are consuming and the taste is having totally different from what they have consumed in the Odisha. Now, that the matter comes to court. Now the court decided that the structure and the way it has been generated having a different kind of value in Odisha itself as well as in West Bengal itself. So they gave both the geographical tag to Odisha as per the quality and the structure of the particular Odisha Rasgulla and the sponginess and the kind of structure in the West Bengal Rasgulla. So both get the GI tag as per the Indian GI tag Act is concerned. So this is the best example of the geographical indication. Now come to trade secret. What is trade secret? Trade secret is the practice or a process of company that is generally not known outside of the company. See, we can say the trade secret of the composition of the Coca-Cola. You can eat it, you can drink the Coca-Cola anywhere in the world. The composition is same. The flavor is same. Because why? It is a secret that will be kept by that particular company to take the economic advantage, right? So nobody else can copy that one. That also comes under the IPR, right? So if you see the Google search algorithm, KFC fried chicken, Coca-Cola, the WD, the multi-cuisine product, the McDonald's Big Mac special sauce. So these are all the trade secret of that particular company only. Now plant variety protection. See, as per plant variety protection, if somebody has developed a particular seed in particular laboratory, they can also protect through the IPR. But if anybody is working on any kind of plant cells or any kind of plant seeds, then as per section 3J of Indian Patent Act, we can say, no, we are not going to give you patent onto that particular plant cells. Though we have having different sets of IP regime in India as per Indian Patent Act 1970 is concerned. But by the same way, you can register on that particular variety of seeds if you have done work in a particular laboratory through Plant Variety Protection Act, whatever you are providing in Indian scenario, right? So before ending our session, let me tell you what are the validity of that particular things. For a patent, it is for 20-year term. And as I told you, there is no such word called global or international patent. Patent is always territorial in nature. It's always within the jurisdiction. For the design, the validity for 10 years, and it can be extended for 5 years. For trademark, you can indefinitely extend the trademark validity, but For every 10 years, you need to file for renewal. For GI, it's also go for indefinitely time. But what is the main difference between the patent, trademark, design along with the GI? For GI, only the group, only the individual can't file for GI. See, geographical indication is only given to a particular section of society, because that particular section of society, that particular land is having a right on that particular product. So that GI only you are not giving it to a particular person. That thing you need to keep in mind. For the copyright, the same way it go for the literary, dramatic, artistic, musical work, and the time is for 60 years and different 25 years, as per I have discussed there, right? So last one, what is the point to remember? First protect, then publish. Whoever working in a laboratory or any kind of work, before publishing your work in any kind of journal, first file a patent. Let's file a patent in Indian Patent Office. And again, I am telling, write it territorial nature. It's not any global nature. Registration is done by the sovereign authority. That means the government of India is only providing you the patent. Whatever the patent right you are providing in India is not valid for US. Because for US, you are also going to approach the US government. As per their sovereign, their right, their act, they will provide you the right. And right is not for absolute term. It's for a limited period of time. There is no automatic relief until unless you are not going to file an infringement suit. When you are having to have a right to file an infringement, if you have registered it in Indian Patent Office or in Indian Trademark Office. Again, to make your IPR alive, you have to periodically pay the renewal fee. So these are the things you need to remember. So after that, I am going to conclude my session, and now I'll open my session for any question here. Thank you, sir. Thank you.
Thank you, sir, for your valued lecture on Introduction to Intellectual Property Rights. You have given a vivid view of IPR, the objectives, the growth of IPR, how to file patent application, what to do, rights of authors for copyrights, scope of economic rights, examination procedures, and all students are definitely benefiting from your elaborate practical scenario which you have put forward before us. Thank you, sir, once again, and I extend sincere thanks to you.
Thank you, ma'am. Thank you very much.
At the end of all, I'd like to take this opportunity, and I would like to request our Pro Vice Chancellor, Madam Dr. Ankita Chakravarti Bhattacharya, to say a few words.
Thank you so much, Dr. Mononita. Thank you, Dr. Niyogi, for giving us this wonderful opportunity, creating this year after year for all our students, all faculty members. We really look forward. I have been through this for the entire day, and no matter how many times we see this revision always gives a pleasure, because this is very, very an important area. So I'm sure, dear students, you would have taken the note of all the experts and the great speakers who have shared their knowledge, and there is much more to learn. So this is just a beginning. So keep learning more and more. Thank you so much, Mr. Subrata Sahu, for giving your precious time to us and enlightening our students, taking them through all the process. The last one especially, where points to remember, were so very true. So just hope that we all have taken our notes and we commit together that we will definitely have our learnings going on. Thank you once again, Niyogi sir, for doing this for us. Thank you, Dr. George. You have really taken a lot of effort to ensure this goes smooth. And Dr. Kundu, you have been fabulous throughout the day. The smile and the energy has not left you at all, even at this hour. It started in the morning. Thank you, everyone, all the participants, dear students and faculty members. Thank you so much.
Thank you, Ankita. Thank you very much. Ankita is like a daughter to me, and excellent. I have been seeing you for after a long time, 3 years or 4 years.
Yes.
Is it correct?
Yes, yes, of course.
Good.
First, you were there in US, and then there was COVID.
All the best, Ankita. And I'd like to specially thank the Vice Chancellor, Dr. Sanjeev Kumar, and Dr. Joshi, Dr. Sunil Joshi, because they have taken lots of pain for organizing this seminar, and the seminar has become very successful. The last speaker, my thanks goes to last speaker, Subroto. Subroto, what is his full name?
Mr. Sahu.
Oh, thank you. Thank you very much for giving details, tidbits of IPR, including the rules, not only the act, but also the rules which provides for the procedure for this thing, for filing for IPR, for a patent, for a copyright, for everything in the IPR. So thanks a lot, and thank you, Dr. Joshi, George, for nicely, Dr. Joshi has showed his confidence and nicely organized this program. Program has become a success. Though I was wanting some question from the students and the faculty members, but I'm here because I'm ready to answer any question on NRDC, IFC, and anybody. You can communicate to them that anybody who wants any help on IPR, we are here. They will write to me or my colleague Jogendra Singh. We will give you the telephone number of Mr. Jogendra Singh. Just try to tell your students, with your permission, they should write to us, and definitely will try to find out help for them. Thank you very much, Dr. Joshi, once again, and Dr. Sanjeev Kumar and Ankita Bhattacharya, whom I call my daughter, and thank you all very much.
Thank you,
and
sir.
Thanks to Ramaranjan also for helping you. All the best. Thank you.
Thank you, sir, for your kind words. I would like to take this opportunity to thank all our distinguished speakers, participants.
Thanks to you, Mononita.
Thank you, sir. I'd like to take this opportunity to thank all our distinguished speakers, participants who have gathered in this online workshop. I am sure that all the deliberations throughout the day has generated fresh ideas, insights, and solutions to our common global issue of intellectual property rights. My heartfelt thanks to Professor Dr. Sanjay Kumar, Professor Dr. Ankita Chakravarti Bhattacharya, Dr. Sunil George, HOI, ALSK, our faculty members, especially Vishal Bera, Priyanka Bishwas, and all our beloved students who have been here throughout the day. Sincere thanks and appreciation to all our logistics, IT, and support staff of Amity University, Kolkata. Before I conclude, it can very well be said that the workshop has been a complete success. Thanks to all of you. Namaskar.
Thank you.